weekly daily list. Test admission item number 1.
That is covered by that Narottam Ratha order, my lord.
All right, both matters.
1 and 2.
All right.
Item number 3.
In spite of the order of the collector, the OP number 2 is not carried out eviction proceeding. Even if the fact finding annexures 5 and 6 series that there is encroachment of the road for which the petitioner is suffering, he cannot enter into his land also. But the OP number 2 is not doing any eviction of the OP number 5, who is encroaching upon the road.
OP number 4 or 5?
OP number 4.
That is
All
no
right,
OP
the
number
petitioner's
5.
representations, bracket annexure 7 series, shall be examined by the executive officer, then Canal Municipality.
Yes. Executive officer, Jhankanal Municipality, OP number 2.
And after notice to the petitioner and opposite party number 4, and after giving them a hearing, the reasoned order shall be passed not later than 24th April. And be communicated to the parties within a week thereafter. The court clarifies it has not expressed.
Item number 4. Item 4.
None appears to see.
Item number 5.
My lord, I am challenging inaction of the OP number 4, my lord, who is not taking initiation for initiating early proceedings against private OP, my lord. Page 19, I have also made an application before the sub-collector, OP number 3. He has also directed to the OP number 4, my lord.
All right. Representations made by the petitioners. Annexure 3. What's the date of that? 18. Okay. Should be examined by sub-collector.
My lord, I have made an application against the Tahsildar, but he did not do so, my lord. Then I approached to the sub-collector, my lord,
All right.
which is page 19, my lord.
The sub-collector comes up divisional magistrate Badrak. Now after notice to the petitioner and opposite parties, 5 to 11. Now after giving them a hearing, a reasoned order shall be passed not later than 24th April. And be communicated to the parties within a week thereafter. All right.
Item number 6.
My lord, on behalf of Mr. Vijay Kumar Mohanty, my lord, he is out of station. I pray for tomorrow, my lord.
All right. The petitioner's representation, bracket annexure 6, shall be examined by the collector Sundargarh.
My lord.
And after notice to the petitioner and opposite parties, 5. And after giving them a hearing, the reasoned order shall be passed not later than again 24th April and communicated to the parties within a week thereafter.
Item number 7.
Similar order may kindly passed.
Disposed of his infractions.
Double to 5 to double the same order may kindly pass.
अरे infractions.
अरे हे ला. दे दिए से order दे दिए.
My lords, my learned friend's name may kindly be recorded.
Already filed.
All right. Same order, same. Yeah. No, not taken on both. Sorry. No. Item 7. Same order. No, he wants a similar order in this.
Item number 8.
No instruction, my lord.
All right. Dismissed. No.
Item number 9.
My lord, item number 9 is covered by Keshav Automobiles. 9 and 10, my lord.
All right. Got that
10,
order?
my lord. 10, my lord, page 20. The assessing authority has held that he has accepted the returns, my
You
lord.
have not communicated that.
Keshav Automobiles.
Now it has
No, no,
gone
what, which order have you given?
further.
Not this, sir. We passed several orders accepting your Keshav Automobiles submission. We passed several orders. Those short orders we're asking copies of.
Sorry, my lord, sorry, my, very sorry, my lord.
Any, all right. See, it is pointed out by counsel for the department that the records show that the assessing officer accepted the returns filed by way of self-assessment. To stop. Nevertheless, the record does not show that such acceptance was communicated to the SSC. Sir, I just request hereafter,
My lord,
passing some 10-15 orders like this,
my lord, my lord.
kindly keep at least one copy.
Sorry, my lord.
This side, they will never keep copies.
My lord,
so
my
we can't depend on them. So
My lord.
you don't have copies, correct? You don't have copies. All right. This applying the ratio of Keshav Automobiles, which has been affirmed by the Supreme Court in Rati States and explained further by this court. Mr. Kara has that copy. So we've got one further Keshav Automobiles too. I can remember that. Not communicated. Communication. All right. We'll just make a whole set of it and keep it with us. Something like that. Correct.
I'll supply the orders by
All right.
tomorrow. Milord.
All the assessment orders and consequential demands are all hereby quashed. All right.
And next, my lord, is Xmas Regents, 3313.
All right. Same thing for that.
Obelisk.
Only will say commerce receipts. All right.
Item 11.
Item 11, Your Lordship, lastly directed to produce the record. But I have obtained the record. Your Lordship, kindly have a glance. I have a certified copy of the order sheet. Your Lordship wanted to know the notice which was issued, whether it was reflected in the order sheet or not. If Your Lordship see the CST, two assessment order. One notice has been issued. It has not reflected in the order sheet of the CST record. It was reflected in the OSC record. Without outing, Lord, this is all the bad record.
No,
This
I'm not able to understand what are you saying, sir?
Here, Miller, the assessment, Lordship, see the annexure 2 running page 15. The notice has been issued and date has been fixed on 11/12/2017 to clarify these issues, Miller. And the very next page is, Lord, my time petition, Lord. The officer on that day was upset. They have not whispered about the notice in the order sheet. In VAT, Your Lordship, see the notice has been reflected so far as VAT that is concerned.
So one is VAT, one is
Yes, Miller.
OET,
Yes,
CST.
yes.
So what you challenge is the CST.
Both, Miller. VAT and CST, both, Miller, tag out there.
Giving him copies of this.
My lord, that is there. Record is, my lord, page 11 of the assessment order, my lord. Second para, my lord. The place of business of the dealer company was visited by the tax audit team headed by sales tax officer Kotak 1 West Circle and such for the purpose of tax audit for the tax period from 1/4/13 to 39/15 as per the program fixed, and after verification of the books of account for the above tax periods have submitted audit report in form VAT such and such.
No, this is about applying his mind, sir, and independently forming an opinion. It's about that. Correct?
Then last para, in response to the statutory notice issued.
This is all post, sir. You're now looking at the time of reopening. This is an order passed in assessment, correct?
My lord.
Now you can have elaborate explanation why you reopened the assessment. What you say at the time of reopening is what is important. Now you can rate reams and reams.
It's 42 assessment, my lord.
Correct,
sir. No reassessment, my lord. Audit assessment, my lord.
All right. Anyway, Indore Limited applies.
No, my lord.
No, my lord.
No, my lord.
Here, Miller, no opportunity is given, Lord.
Yes, challenge
but the notice is given. An audit visit report has been furnished to you.
Yes, my lord.
But the issue is clarified. Notice has been issued for clarification. That has not been awaited for me to clarify this issue. That order has been passed. That is the issue, Lord.
Is challenging the expiry order, my lord. But He has participated and produced his books
No,
of.
but he's asked for time, no?
Yes, and that issue which has been asked for, he has reflected in the order recently without next place 12. In further, it is observed. Without outing for my explanation, though I have filed the time petition. On that day, the officer was absent. And order sheet, your lordship, see the CST order, they are not whisper about that notice even.
No further time.
He has not reflected.
All right. I think both these together. Both these petitions arise out of a similar set of facts and are accordingly been disposed of in this common petition. In Petition Civil 3280 of 2018, the challenge is to an assessment order dated 29 December 2017, passed by the Deputy Commissioner of Sales Tax, Cuttack 1, West Circle, Cuttack. Under Rule 12, bracket 3 of the CST bracket Orissa rules, the tax period 1st April 2013 to 30th September 2015. Paragraph at Petition Civil 3281 of 2018 challenges an assessment order of the same date under Section 42 of the Orissa Value Added Tax Act 2004 bracket OVAT Act. Both impugned assessment orders was as a result of an audit visit and submission by the team of an audit visit report bracket AVR. Paragraph. The short issue raised by the petitioner in both matters is that after the AVR report was furnished to the SSC, an application had been filed for postponement of the proceedings to enable the SSC to give a proper response to the report. Paragraph. No, full stop. The SSC contends that this request, which was not unreasonable, was rejected by the AO, who proceeded to pass the impugned orders. Paragraph. The copies of the order sheets of the AO in proceedings under both the CST bracket O rules as well as the OVAT Act have been produced before the court. Full stop. The noting of 27th December 2017 in the proceedings under the OVAT Act acknowledge that counsel for the petitioner had filed an application seeking further time of 1 month since the for production of documents in response to the AVR. Full stop. The rejection of the request was on the ground that open petition case is to be disposed by end of December, that is 31/12/2017, as the notice for assessment has been served on the dealer on 1/7/17, unquote. Thereafter, within 2 days, the impugned assessment order has been passed. Also, it is pointed out that he was on leave on which date?
On date of 11/12/2000. I've heard him, Lord.
The further fact is that on 16/11/2017, sorry, on 22/11/2017, the proceedings note that the dealer has been intimated to submit the details. And the next date was in fact fixed as 11/12/2017. Full stop. It transpires that on 11/12/2017, the AO is absent. Full stop. Thereafter, on 27/12/2017, he took up the matter and rejected the request of the SSC for time without the SSC having notice of that date of the proceedings. Full stop. As a result, perusal of the impugned order reveals that when the final, when it was passed, it was the SSC had not participated in the proceedings. Full stop. The position under the CST proceedings in the proceedings under the CST bracket O rules is no different. Full stop. Here, the request, the fact that the SSC made a request for time is not even acknowledged or rejected. Paragraph. Having heard letter counsel of the parties, the court is of the view that procedure adopted by the AO in both instances cannot be said to be reasonable. Full stop. The court is of the view that there was a denial of an effective opportunity to the SSC to properly defend itself in the proceedings by producing documents to explain what has been pointed out by the AVR. Paragraph. For the aforementioned reasons, the input assessment orders are hereby set aside and the matters are remanded to the AO. That is the Deputy Commissioner of Sales Tax. Even today, some designation changes, right now?
Your Lordship say assessing authority, it will be.
All right, concerned assessing authority. So stop, it will be listed before the concerned, the matters will be listed before the concerned assessing authority on 3rd April 2023 for being proceeded with in accordance with law afresh, uninfluenced by the orders that have been set aside by this court.
Both the matters similar.
The petitions are disposed of in the above terms. No orders, of course.
One is CST, one is patent. Both the same. Much obliged.
Item number 12.
Similar order may be passed.
All right.
Item 13.
13 kindly pass over it.
All right.
Item number 14.
Whereas item 14 and 41 are same as. Your Lordship will remember that application for compounding was rejected solely on the ground of limitation without being aware of the order of the Supreme Court. And I am giving without being aware of the order of the Supreme Court that corona the limitation was relaxed. One item 14 relates to the assessment of 15-16 and item 41 relates to 16-17.
Yes.
All right. Same order. All right. Same order.
Item number 15.
It may please your Lordship, my Lord. My Lord, section 25, subsection 1B of the Orissa Gram Panchayat Act provides that if a person has begotten 3 children after 18/4/1995, he or she is disqualified to contest the election of the Gram Panchayat for the post of Sarpanch or other post, my Lord. In the instant case, one member of the Gram Panchayat, Mahabara Gram Panchayat, under Dunguripalli Panchayat Samiti in the district of Subarnapur, filed a petition under section 26 of the Orissa Gram Panchayat Act for disqualifying the Sarpanch, present Sarpanch, as she has begotten 3 children after the cut-off date, my Lord. Along with the petition, I filed the public documents, my Lord, the voter list, the board certificate, central board certificate in which the last child passed the class 10.
It's only remitted to the collector for a fresh disposal, sir.
On the ground, my Lord, the honorable single judge called for the record on 8th February, my Lord. Record had not been reached, my Lord. On 13/2, on the ground that to allow the cross-examination of the witness, my Lord, the Anganwadi worker, the matter was remanded, my Lord. Your Lordship kindly see the respondent 6 declined to cross-examine and file a memo on 12/1/2023 at page 15 under annexure 1 to this writ appeal.
No. How is this prejudicial? It just has to go back to collector for a fresh procedure.
My lord, when a party declines to cross-examine the witness and file memo, I am reading that language of the memo. The advocate for opposite party, that opposite 6, respondent 6, has already closed the matter. Written notes of argument has already been filed.
So this is not some criminal trial or something.
No, matter may be posted for final order, my lord. This is his prayer, her prayer, my lord, before that. Once the collector taking into account all the documents, all the public documents, decided that she has 3 children after the cut-off date, my lord, then only for cross-examination of the Anganwadi worker, my lord, the matter has been remitted, my lord. I file all the documents before Honorable Single Judge. All the public documents are admissible under section 35 of
Has
the
it been
evidence.
made time bound or not? That's the only question.
Time bound is there, my lord.
Then
3 weeks.
it's not
3
no
weeks.
prejudice. These kind of orders we should not.
And today he is supposed to appear before the collector.
So
I appeared, my lord. My lord, it will continue like this, my lord. When all the public documents before Honorable Single
it's all
Judge.
it's time bound, sir. It won't continue endlessly. That's why I asked. If it is time bound, then that
It is time bound, my lord.
then it's not a problem. Since the impugned order is only an order of remanding the matter to the collector for a fresh disposal, and it's also been made time bound, the court is of the view that it does not call for any interference, leaving it open to the appellant to urge all points raised in the present appeal in the remanded proceedings. The court, without expressing any view on merits, disposes of the writ appeal. All right.
Well, one thing, my lord, the Honorable Single Judge directed to restore that sarpanch in her post.
Only till this time, sir. It's all right.
Item 16.
In this case, the petitioner has filed a review petition challenging the order of this honorable court dated 17/2011, passed in application number 581 of 2011. And I kindly peruse the page 3 of my review petition. I have quoted the order of this honorable court, where last para, the said original application was filed before the tribunal on 10/12/2010 from instruction obtained by the learned additional commander from the executive Prachi Division, Bhubaneswar. It appears that the petitioner had been regularly in the post of Khalasi, which is, my lord, wrong. My lord, I have already, my lord, enclosed in my review petition, my lord, Annexure 7, that I have been retired as a watcher's employee, my lord. But I have never been regularized. But on the basis of the wrong submissions, the order of this learned tribunal has been read. May I kindly peruse the last annexed to my review petition, my lord.
So you've lived with this order for 12 years now.
My lord, in time, I have already filed, my lord. In the meantime, because the petitioner has worked since 1982.
It's all right.
And there is a decision of this honorable apex court that the persons as regularly in watcher's assessment, continuing in the watcher's assessment, will get the pension benefit, my lord. But the petitioner will suffer a lot because he has never been regularized in. Can see my the annexure only, my lord, that I have never been regularized.
It's all right. No ground.
I can peruse that my apex court order that the persons will be served in watcher's assessment can be. I am sought for review only that this honorable court has not taken into consideration the fact that the petitioner has never been regularized.
Right.
Para 6, my lord.
Yes.
That's it.
Yes. We ourselves have got only one copy, sir. If we give away your copy, then poor man, he can't read. So, read it now. He can at least listen.
Concept of a one-time measure was further explained in para 9, 10, and 11 of the report, which read as follows. The term of one-time measure has to be understood in its proper perspective. This would formally mean that after the decision in Umadevi, each department or each instrumentalist should undertake a one-time exercise and prepare a list of all casual, daily or ad hoc employees who have been working for more than 10 years without the intervention of the courts and tribunals and subject them to a process verification as to whether they are working against the vacant post and possess the requisite qualification for the post, and if so, regular their services. Next, at the end of 6 months from the date of decision in Modibi, casual of several daily wage ad hoc casual employees were still pending before the court. Consequently, several departments and instrumentalities did not commence the one-time regularization process. On the other hand, some government departments or instrumentalities undertook the one-time exercise, excluding several employees from consideration, either on the ground that their cases were pending in courts or due to sheer oversight. In such circumstances, the employees who were entitled to be considered in terms of para 53 of the decision will not lose their right to be considered for regularization merely because the one-time exercise was completed without considering their cases or because the 6 months period mentioned in para 53 of the Umadib has expired.
Item 17.
Wait, please, Manoj. Manoj, I appear virtually, Manoj, in this matter. Manoj, in this case, Manoj, there's an IA at flag B for delay condonation, Manoj. Delays of 34 days, Manoj. in
All right.
referee.
Yes, delay yes.
Yes, Manoj, the application, Manoj, challenges the order of the tribunal, Manoj, in dismissing the appeal solely on the ground of delay. Now, Manoj, the order is at page 31, the impugned order. The questions of law is at page 11. Manoj, sir, the delay.
Is that typographical error or is correct?
Yes, Manoj. That is what I'm addressing, Manoj.
Yes.
The delay is of 2569 days. Plus the ground taken, Manoj, says that the conducting counsel who was dealing with this file, Manoj, died. He was suffering from kidney ailments. Then subsequently he died on 6th of August, 2012. Thereafter, Manoj, only when the department pressurized the dealer, there the dealer got to know that no appeal has been filed. Now, Manoj, if your lordship will permit, Manoj, if I may take your lordships to the merits in order to ascertain whether there is any substantial justice that is required. Here is a case. Manoj, the first appellate authority himself, your lordship may kindly have for a moment, Manoj, page 23, Manoj. The observation of the first appellate authority against the order of the first appellate authority, page 23.
Yes.
At relevant page 26, Manoj, may kindly have.
Yes.
Manoj, we'll see 6 lines from the top, Manoj. Prima facie.
Yes.
I find that the principle of natural justice has not been extended to the dealer, and there is no record as to service of statutory notice or intimations in this regard to the dealer in the assessment record. Therefore, the contention of the principles of natural justice has been violated in this case appears to be positive in sense and substance in the light of the observations of High Court, Honorable High Court and Apex Court as above. It is a fact that the principle of natural justice must be read into the unoccupied intricacies of the statutes unless there is clear mandate to the contrary. Besides, it's also an inseparable ingredient of fairness and reasonableness and pragmatic requirement of fair play in action. Therefore, when the file has been reopened under section 12.8, it's a 12.8 is a reassessment under the Odisha Sales Tax Act. Where the file has been reopened under section 12.8, the statutory notice issued must be served on the dealer and reasons of application of the facts in the report against the dealer before rejection of books of account, best judgment of the dealer should be extended with adequate opportunity of being heard, which has not been followed in the instant case. Thereafter, Milord, subsequently, the first appellate authority records on minute verification of the fraud case code. I find it is not proper to arrive at a concrete conclusion without examination of fraud case report with detective slips and its proper confrontation to the dealer appellant or his authorized advocate. Milord, this is the finding of the first appellate authority. Now, despite this finding, the first appellate authority, instead of quashing the assessment order, Milord, confirms a part of the assessment order. Now, here, Milord, admittedly there has been violation of the principles of natural justice. There is no appeal by the department against this order or against this finding. The finding insofar as lack of opportunity, Milods, that finding has been crystallized. So, Milods, in this, and also, Milods, this next point is, Milods, there is no recording of reasons for reopening of assessment. So, Milods, here is a clear case where substantial justice, Milods, may kindly have a look at. Milods, your lordships is aware, there's the judgment of Master Karji that collector land acquisition versus Master Karji, that judgment is there. Your lordship must have seen that judgment, but if your lordship will permit, just face that judgment.
The minute we start equating land acquisition with the tax, there's a serious problem, sir.
No, I understand, Milods, but Milods, Malik, kindly have a look at para 3, Milods. The principles have been
correct.
Para 3, Milods, if your lordship turns over the page.
Correct.
Ordinarily, a litigant does not stand to benefit by lodging an appeal.
Correct. So the litigants in land acquisition proceedings are of a certain strata of society, sir. It is in that context that all these observations are made.
That's the only thing. I know I am facing. I know the difficulty. I know I have an uphill challenge.
Correct.
Only thing, Milods, is that such an illegal order will get perpetuated, Milods.
Not really. Not really. If you want, we'll clarify. It will not create a precedent. That's all.
No, not about a precedent. Milods, that I will then stand remediless against such an order. So, and which has not extended any adequate opportunity, and that is a recorded fact, Milods.
Yes.
In that way, I implore your lordships to kindly, Milods, interfere in this matter.
Or you say that the present division petition is directed against an order dated 7th May 2016, passed by the Odisha Sales Tax Tribunal, Cuttack (OST) was tribunal, dismissing the dealer SSEs SA number 48/15-16 on the ground of delay. Full stop. The perusal of the impugned order reveals that there was a delay of 2569 days in the SSE filing the said appeal against an order dated 28th April 2008, passed by the Assistant Commissioner of Sales Tax (ACST) Cuttack 1 range, partly allowing the appeal by the petitioner SSE against the assessment order of the Sales Tax Officer Cuttack 1 under Section 12(8) of the Orissa Sales Tax Act for the year 2003-04. Full stop. In partly allowing such appeal, the ACST had reduced the demand of rupees 984,476 to rupees 389,130. Full stop. Agreed by to the extent that the appeal was not entirely allowed, the aforementioned second appeal was filed before the tribunal, but with a delay of 2569 days. Paragraph. The reasons put forth in the application for condonation of delay before the tribunal was that the lawyer handling the case had suffered from a serious illness and ultimately died on 6th August 2012. Full stop.
Would your lordships need a
papers
copy
had
of
been
that?
entrusted to such advocate to file the appeal, but the SSE had not bothered to follow up with the advocate to ascertain whether in fact the appeal had been filed or not. Paragraph. The tribunal was not convinced with the reasons adduced and therefore declined to condone the delay. Paragraph. Mr. Acharya and counsel for the petitioner placed reliance on a judgment of the Supreme Court of India in Collector Land Acquisition versus MST Katiji 1987 2 SEC 107, where observations have been made that there must be a justice-oriented approach in examining if there was sufficient cause for condoning the delay. Full stop. Paragraph. The above decision arose in the context of the Land Acquisition Act. Full stop. It acknowledged that persons before the courts in such cases may not be persons who will be aware of the complications or the complexities of the legal procedure. Full stop. Paragraph. The court is of the view that what was expressed in the context of land acquisition proceedings cannot ipso facto be extrapolated in proceedings like the present one, which arise under the sales tax legislation. Full stop. Here, the SSC is fully aware of the requirement of having to file appeals within time. Full stop. After all, the petitioner is a dealer registered under the Orissa Sales Tax Act and is aware of the necessity for filing returns, for challenging demands before an appellate authority, and of the fact of the further appeal before a second appellate authority like the tribunal. Full stop. Paragraph. The long and short of the above narration is that as far as the SSC is concerned, the explanation offered for an extraordinary delay of 2569 days was not convincing at all. Paragraph. Mr. Acharya then sought to place the merits of the matter to urge that there was an egregious error committed by the ACST in only partly allowing the appeal and reducing the demand. Full stop. Since the essential question as far as the present revision petition is concerned is only about the justification for the tribunal not condoning the delay of 2569 days, the court would not like to delve into the merits of the matter. Full stop. No substantial question rises from the impugn order of the tribunal. The revision is dismissed.
Item number 18.
Grateful.
Please, my lords.
Great.
The IA's, my lord, is for dispensing with filing of certified copies, which are the assessment order and the first appellate order, my lords. And the impugned orders, Annexure 3, that's the tribunal's order, have already filed it, my lords. And so far as the tax revision is concerned, my lords, I'd humbly pray that the IA may kindly be allowed. And,
IA is allowed.
And so far as the tax revision is concerned, your lordship may kindly turn to page 7, my lords.
Yes.
Now, I would only call upon your lordships to consider questions D and E, my lords. D reads as thus, my lords, whether the learned tribunal is correct in rejecting the books of accounts on the allegation of suppression occurred due to difference in figures between the books of accounts and the return figures, undisputedly when the subsection 4 of section 42 does not prescribe for rejection of books of accounts as well as best judgment assessment. E is whether the tribunal was correct in restoring the order of assessment where the ITC was disallowed on the ground of mismatch, admittedly when the said ITC has been allowed by the first appellate authority because the order of the revision authority in restoring the registration certificate of the selling dealer. The facts of this case, my lords, is there was a clerical mistake, my lords, of when the returns were filed, my lords. And the books of accounts, my lord, if your lordship would kindly turn to page 25, my lords, of the first appellate, which is a part of the first appellate order, my lords. The first appellate order begins at page 23. The lordship would kindly come to page 25. The last two lines, my lords. May I just place it?
Yes.
In this forum, the learned advocate produced the books of accounts, which on verification revealed that the dealer has not followed the accepted procedure of bookkeeping as per the provisions of law, which resulted in discrepancies in sale and purchase reflected in the returns filed vis-a-vis the books of accounts. The learned advocate further submitted that in this forum that the discrepancies arose on account of errors committed by the accountant of their concern. Thus, it appears that the dealer has disclosed higher turnover in the books of accounts than that disclosed in the returns. Though the dealer explained to the LAA that due to the mistake of the accountant, the lower turnover was disclosed in the returns, the learned assessing authority did not accept the submissions and established purchase suppression of rupees so and so, and sale suppression of rupees so and so. Then my lord, he accepts my books of accounts, and according to my books of accounts, he allows the ITC, my lords. And that's your lordship would get it at the last two lines, my lord, of that page, my lords.
Yes.
However, in view of the discussions made earlier, ITC of rupees so and so, as claimed as per books of accounts, is now considered as admissible ITC and now determined as so and so, my lords. For the second question,
There was a discrepancy between what you filed in the returns and what the books of accounts said.
no, there was a discrepancy because I said that the accountant made a mistake, my lord, while he has, there was a clerical mistake, my lord, in my return figures, my lord. That was accepted. And my assessment and the first appellate authority went by my books of accounts, which were audited books of accounts.
All right.
And your lordship would see, so that the second question is concerned, my lord, the selling dealer's RC was...
Anyways, a notice has to go.
Now the revenue goes up in the second appeal, and the tribunal, my lord, he discussed the entire thing. He says that no, the returns have to be followed, even though my audited books of accounts have been followed, and he restores the assessment order, my lords.
All right. You just say admit the following question straight for consideration: whether the tribunal was justified in reversing the order of the first appellate authority, which had held the demand raised to be unjustified, since the audited books of account of the SSC were wrongly rejected by the assessing officer. Then you say the record of the, you need the record to come, the record of the assessment to be requisitioned for the next date.
And the other, if your lordship would pardon, the other one, my lord, the selling dealer's RC was restored with retrospective effect, that which covers my date of purchase. So that was also allowed, my lord. That was also my second question.
All right. Which is question E, is it?
But that's question E, my lords.
All right. E also you take after this question. List on 30th August. All right. Record and first appellate. All right.
30th August.
Record is
Yes.
necessary. He has taken into consideration.
First appellate authorities.
There's a prayer for extreme orders, my lord, subject to your lordship.
And this notice of
Notice,
that.
man.
All right. All right.
30th August.
August.
Item number 19.
This case, my lord, also there's an IA for dispensing with filing of certified
There's some
copies.
delay.
My lord, no, there's no delay, my lord.
118 days.
Uh,
What's the explanation?
Yes, my lord. The explanation, my lord, is
File
of 116 days, my lords. My lords, I have given, my lords, at page 2, my lord, paragraph 3 of the delay condonation application.
File misplaced.
My lords.
What's the merits?
Lord, merits, my lord, your lordship would appreciate that there was a raid by the Director General of Central Excise Investigation Unit, my lords. So basing on these documents, my lord, a 12-8 proceeding under the Odisha Sales Tax Act was initiated, my lords. I filed an application for confrontation of certain officials, my lord, of the DGGI, and also, my lord, certain dealers of the who my lord, is alleged that I have sold goods to them, my lords. What the assessing officer does, my lord, he only considers those 3 dealers, but forgets about the DGGCI, my lords. And he says that since they did not appear, so you also did not appear on that day, I accept the documents which was given by the Central Excise authorities, and I enhance the assessment order and I close it. The tribunal, my lord, they say, my lord, since the Central Excise authorities are central authorities, so the sales tax officer has not committed any wrong in relying upon the...
No, but you were not there to cross-examine.
No, the cross-examination, none, my lord, it was not allowed. What has happened, my lord, your lordship may kindly turn to page 17, which is my application before the sales tax authority for cross-examination.
No, but I thought you were not present on that day.
Yes. Only, my lord, what has happened, my lord, there was 2 parts. On a one day, my lord, I was not present. Then I said, my lord, it was not recorded, that please also summon the Central Excise authorities, my lord, and certain documents which you have relied, my lord, has to be confronted to them. That part was never considered, my lords. What he does, my lord, if your lordship would kindly see the assessment order, my lords, he only sticks to the first part at page 18 of the assessment order. Your lordship would kindly see on the basis, your lordship, page 18 of the assessment order.
Yes.
On the basis of the prayer made by the dealer to cross-examine Sri So-and-so, partner of Khandagiri Traders, Sri So-and-so, proprietor of Rameshwar Traders, Sri So-and-so, managing director of Steel Company, summons were issued to them for appearance. Only Sri Ajay Kumar Agarwal of Messrs Steel Companies appeared on date fixed, that is 7/12/2009, but the dealer failed to avail this opportunity. And he stops at that, my lord. He does not discuss even what Ajay Agarwal says. Then your lordship, if your lordship would at this moment not turn
B
to,
and D, I think we can frame questions on B and D.
no, I was only humbly praying, my lord.
Yeah,
But I was just humbly praying, my lord, subject to your lordship's kind consideration. Now my central excise appeals are pending in various stages of appeals, my lord. If your lordship would be kind enough, my lord, to relegate me to the assessing authority, let him consider for confrontation, or at least the first appellate authority.
Yeah,
So that will solve the problem, my lord.
But let's hear you say admit.
But I
the
don't think
following-
my learned friend will have an objection. Only well, if it goes back, my lord, only for the purpose of
Finding has
confrontation.
been clearly given by the assessing authority as well as by the tribunal, my lord.
No, tribunal has not given any opportunity. They rely on the observation of the assessing authority. They don't give me an opportunity
He
for
wants it to go
confrontation.
back to the assessing authority.
Not only for the purpose of confrontation. Because my lord, this will have far-reaching consequences because my central excise appeals are pending in various stages, my lord. And if any adverse, I suffer any adverse order, my lord, that will be, my lord, again relied upon by the central excise authorities, not to
Admit B and D. Questions B and D. The record of assessment as well as the first appellate authority. The requisition for the next date. We'll have it on 31st August. Right.
Item number 20.
I've in this case just reframed the questions, my lord. I'm grateful to the available technology, my lord, now because I'll be having the opportunity of sharing with the lordship the Keshav Automobiles short order, my lord.
I see, yes. Okay.
I'm just giving
All right.
the reframed question. So what has happened in this case, my lord? If the lordship would kindly turn to page 15.
Yes.
Here, 42 assessment was earlier completed for the period 1/4/2009 to 31/1/2010. Then, my lords, a 43 assessment was initiated for the period 1/4/2009 to 31/3/2011, my lords. So this period of 1/2/2010 to 31/3/2011, my lord, has to be deleted, my lords. And that your lordship would get it at page 15 of the assessment order, my lords. At paragraph 2. After running page 15, my lords.
Yes.
After completion of assessment under section 42 of the Act for the period 1/4/2009 to 31/10/2010, as well as assessment under section 39(2) of the Act for the period 1/2/2010 to 31/3/2011, after receipt of returns and the subsequent receipt of one tax evasion report against the sales tax officer, so and so, he initiates a proceeding under 43 minutes. So this period, my lord, from 1/2/2010 to 31/3/2011, even though they say that they have been completed under section 39, my lord, there's no communication. That particular order of your lordships, which if your lordship would permit me, my lords, I'd ask, request.
Only 42, that period,
Part period.
Not
that part period.
Has to be sent back to be reworked.
My
Where
lord.
is the order?
And that is, my lord, that has to be quashed because your lordship would kindly see the period in question, my lord, that has to be deleted from 1/4/2009 to 31/3/2011, my lords. That has to be deleted.
Correct. Where is the order, sir? What is only here?
I've shared with the lordship that Keshav Automobiles order, but your lordship, we are not dealing with the deletion part in this order.
You say, admit the following questions framed for consideration. Take it as revised question. It is an admitted position that the imputed assessment order covers two periods. So one is the period covers the period. No, the admitted position is that the imputed order covers the period 1st April 2009 to 31st March 2011, of which for the period 1st February 2010 to 31st March 2011, there was, preceding the assessment under section 42 of the Act, only a self-assessment under section 39(2) of the OVAT Act, the acceptance of which was not communicated to the petitioner. So therefore, the said period, the demand relating to the said period, that is 1st February 2010 to 31st March 2011, will have to stand quashed in view of the judgment of this court in case of automobiles, as affirmed in Rathi Steels, as well as the further order dated 28 November 2022 in writ petition civil 10349 of 2016, Messrs. Pavan J. Sponge and Limited, Rourkela versus Deputy Commissioner of Sales Tax, Rourkela. Paragraph. In that view of the matter, the proceedings before the, it is directed that the proceedings before the AO, it is directed that the AO will now recalculate the demand in the above terms. And for that purpose, the matter will be placed before the IO on 10th April 2023. Against the rework demand, it will be open to the petitioner to seek appropriate remedies in accordance.
So I may be given an opportunity.
In accordance with law. So,
obligement.
Right.
Item 21.
May I please, my lord, there is delay for about 1 day, my lord.
Or delay condo. Yes.
My lord, the substantial question of page
yes. All right.
9, my lord. The number 1, my lord, whether the Learned Tribunal was legally justified to hold that the order of first appeal passed was correct in law, even if passed after lapses of 2 years from the date of hearing, my lord. Then the number 2, my lord, whether the tribunal was legally proceeded and correctly held without any specific reason to disallow the transaction claimed under section 5(3) of the CST Act made through valid statutory form H and not disputed in the tax evasion report by the vigilance wing, my lord. And the next question, my lord, Roman IV, whether in the facts and circumstances of the case, the order of assessment passed under Rule 12(4)(c) of the OST rule and affirmed by the same by the appellate authorities to justify the GTO and TTO determined at rupees 21,24,000, my lord, which is over and above the GTO 20 lakhs. And the Roman V, my lord, whether the Learned Tribunal has legal...
All concurrent findings, sir. First appellate tribunal.
No, my lord. Kindly have a glance. There are 2 invoices. This is only for 1 month period, my lord, disputing 1st March to 31st March 2010, my lord. There are 2 invoices. Sale in course of export, my lord. One is invoice is 22 February 2010. And the page 12, my lord.
Oh, this is fresh matter or at notice returnable. 28th August.
Item 22.
He accepts notice with the department. All right. The record of assessment, the requisition for the next. Okay.
Item number 22.
None appears dismissed. The IA.
Item number 23.
May I please, your lordship? The petitioner may permitted to file a fresh representation along with annexure 13, my lord, before the Secretary of School and Mass Education to...
All right. Petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation to the authorities concerned in accordance with law and after following up on such representation to seek appropriate remedies. This post office withdrawn, liberty is paid for.
Along with annexure 13, my lord.
What was? Yes.
Item 24.
Oblige, my lord.
24.
Then item 24, permit to withdraw to file a better petition.
All right. Post office withdrawn with liberty to file a better petition.
Item 25.
It is here now.
Same matter he removed on that day.
How many such petitions do you have?
That I wanted to know where he's saying. You collect a copy of that. I can give him the copy of that.
All right. the court is already seized of petitions concerning prison reforms.
Second number.
Full stop. There's no need to multiply those petitions with another petition like the present one for similar reliefs. Accordingly, the petition is dismissed.
Item number 26.
My lord,
Permit me.
before my learned
Speak in
friend
India.
starts,
This is
let me submit one thing. He has implicated the Honorable Chief Minister as opposite party and Governor. And another very interesting point your lordship may see from the representation that he came to know that the government is going to enhance the salary of the MLA.
Why are the MLAs not coming asking for salary enhancement?
So there is no, he is not saying
he
that
wants
it is
to be declared illegal. Acha.
Pardon?
He wants that decision to be declared illegal.
No, that decision has not, according to him, we are going to take a decision. Your lordship may see, that is very interesting. That is what I wanted to draw your lordship's attention. Para 2 of the representation. This is a page number. There is no paging even. That it is also came to know that Odisha Legislative Advisory Committee is going to consider the demand of salary hikes of the legislator and is likely to be happened soon.
Yes, Mr. Jena.
If the said demand of MLS.
No, you allow him to talk.
5-6 dekhantu that it is respectfully submitted here that an analysis by NGO Odisha election was found that out of the 147 MLs elected more than half were crorepati's. Out of the total members, 76 MLs are crorepati's from the Biju Patnaik Janata Dal and 9 from the Bharatiya Janata Party. The average assets of the 147 MLs was found to be rupees 3.22 crores. In this situation, such decision is illegal, arbitrary, and should have not taken by the government.
No decision taken yet, sir. No decision has been taken yet.
According to his representation, I am submitting from his representation, para 2nd, para 3, para 2 is going to consider the demands of the government.
All right.
It is likely to be happening.
So whenever it happens, then you can.
ଯାଉଛନ୍ତି ବର୍ତ୍ତମାନ ତାପରେ ଗଲା ପରେ ତ କିଛି ହବନି ତ ବର୍ତ୍ତମାନ ଯୋଉ ପାଣ୍ଡାମିକ ସିଚୁଏସନରେ ଲୋକମାନଙ୍କର ଆଣ୍ଠୁ ମାଣ୍ଠି ମାନେ ମେରୁଦଣ୍ଡ ଭାଙ୍ଗି ପଡିଛି ଦେଖନ୍ତୁ ତାପରେ କି ଅବସ୍ଥା ଅଛନ୍ତି ତେଣୁ ସେଥିପାଇଁ ପ୍ରଜା ଲାଗି ରାଜ୍ୟ ନା ଲୋକଙ୍କୁ ପ୍ରଜାଙ୍କୁ ନେଇକି ଫର ଦି ପିପୁଲ ବାଇ ଦି ପିପୁଲ ଅଫ ଦି ପିପୁଲ
ସେମାନେ ଏପର୍ଯ୍ୟନ୍ତ ଡିସିସନ କିଛି ନେଇନାହାନ୍ତି
ନବା ପାଇଁ ତ ସବୁ ପ୍ରକାର ପ୍ରେସର ହେଇଛି ଏବଂ କମିଟି ଡିକ୍ଲେୟାର କରିଥିଲେ
ଯେବେ ଡିସିସନ ନେବେ ସେତେବେଳେ ଆସିବେ ସେତେବେଳେ ହିଁ ଚ୍ୟାଲେଞ୍ଜ କରିବ
ପାଣି ଥାଉ ବନ୍ଧ ଆମର ଗୋଟେ ଓଡିଆରେ ଅଛି ପାଣି ଥାଉ ବନ୍ଧ ବାନ୍ଧରେ କୁମର ପୁରୀ ରହୁ ସରୋବର ପାଣି ଯେତେବେଳେ ଗଡିଯିବ ଲାଭ କଣ ସେତେବେଳେ ସେ କରିନେବେ ଷ୍ଟେପ ଲାଭ କଣ ଡ୍ରାଷ୍ଟିକ ଷ୍ଟେପ୍ସ ମାଇ ରିକ୍ୱେଷ୍ଟ
କୋର୍ଟ କେବେ ବି ଆଣ୍ଟିସିପେସନ ରେ କିଛି ଅର୍ଡର କରନ୍ତିନି
ନ୍ୟୁଜ ପେପର ଆନେକ୍ସର ହେଇଛି ଦେଖନ୍ତୁ
ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ହିଁ କହୁଛି ସେଇଆ ଯେ ଏପର୍ଯ୍ୟନ୍ତ ଡିସିସନ ନିଆଯାଇନି ଆପଣ ଆଣ୍ଟିସିପେଟ କରୁଛନ୍ତି ନିଆଯାଇପାରେ ବୋଲି ସେଇଟାକୁ ଆମେ ବନ୍ଦ କରିପାରିବୁ
ନବା ପାଇଁ ତାଙ୍କର ଗୋଟେ କମିଟି ଏବେ କହିଲେଣି ଗଠନ କଲେଣି ଗୋଟେ କମିଟି କଲେଣି ଗଠନ ହବନି କେମିତି ହେଇଗଲା ପରେ କଣ ଥାଇକି
କମିଟି ରିଜେକ୍ଟ ବି କରିଦେଇପାରେ କମିଟି ନ
କମିଟି ଏବେ କଲେଣି ତେଣୁ ତମେ ସ୍ୱାର୍ଥଟା ଟିକେ ନଥାଲେ କେମିତି ହବ ଦେଖନ୍ତୁ ଗଣତନ୍ତ୍ରରେ ଯଦି ସମାନ ଭାବରେ ସମସ୍ତଙ୍କୁ ବଣ୍ଟା ନ ଯିବ ଇକ୍ୱାଲ ଡିଷ୍ଟ୍ରିବ୍ୟୁସନ ଭାଉଲେଟ କରିବ ତାହେଲେ ତ ଦେଶର ଗୋଟେ ଅସ୍ଥିରତା ସୃଷ୍ଟି ହବ
The petitioner has come before the court
ସୁସ୍ଥ ଗଣତନ୍ତ୍ର ପାଇଁ ଗୋଟେ
the decision of the government of Orissa to enhance the salaries of the MLAs oblique MPs is illegal. Full stop. Mr. D.K. Manthil, an additional government advocate, informs the court that no such decision is in fact yet
on the representation itself, I am saying.
No, full stop.
Because I have not obtained
right, sir, 1 minute, 1 minute. He refers to the representation of the petitioner, which itself acknowledges this fact. paragraph. In that view, the matter, the petition is premature and is dismissed.
Item 27.
Thank you.
My lord, 27, my lord, 2 days time may be given to remove the defects, my lord.
It's a matter. No, it's already an order passed by the sub-collector. If you're agreed with the order of the sub-collector, you can go in further appeal.
My lord, only 2 days time may be given to remove
No,
the
no,
defects.
sir. What you've challenged is an order of the sub-collector, right? Annexure
Yes,
5.
appeal.
Ah. There's a further appeal against that.
A revision before the collector.
They've seen that the present petition challenges.
Pass over, the conducting council is in another court. So,
All
my
right,
lord,
pass
can
over.
Item 28.
May I please, your lordship. My annexure is annexure 3, your lordship, that is pending before the collector, that is opposite party number 4. And joint responsibility collector and your deputy chairman, State Pollution Control Board. They have to take steps.
These pollution.
This is all NGT, sir.
My lord.
Permitting the petitioner to avail of, to approach the National Green Tribunal to avail the remedies prayed for in the present petition. The relief prayed for in the petition. The petition is disposed of. All right.
Item number 29.
Please, your lordship, in this AL application, the petitioner seeks your lordship direction to the government to protect and to preserve the stadium, which has been built with government money by spending 50 lakhs rupees. Your lordship may kindly see the land.
And with the petitioner's representations.
Is being used as a stadium at Kalimela. That is the bordering area of the.
Just come to Annexure 9, sir.
Annexure 9. Yes, my lord.
What is that?
Representation has been addressed, but no step, because these people, opposite party number 6 to.
Just let me complete the question, sir. If with your kind permission, can I complete my question?
Yes, madam.
Yes. Annexure 9.
Yes, madam.
Show us where you have actually delivered it to the person you have addressed to. What is the proof of delivery?
No, it is addressed to the Chief Minister.
Chief Minister and to the Secretary.
Let him answer the question. Kindly, have you understood the question I asked you? No.
Again.
That's why it's useful to have a division bench.
Sorry, my lord. Your lordship.
He will repeat the question. No problem.
So kindly show us the document where we can know that that document has been delivered to the proper person.
That is acknowledged.
Now you have not understood this question also.
Yes, my lord.
Finally.
Yes.
Very good. Very
yes,
good. Now let's.
Representations have been given that postal receipts we have not annexed. That is the problem.
So whenever you find you make this time when you make representation, keep that very carefully with you. All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation in accordance with law and after following a person's representation to seek appropriate remedies.
Yes.
Petition is disposed of as withdrawn with the above terms. All right.
Because government money to the tune of 50 lakhs has been spent. And this is
Item
being
30. Item number 30.
May I please, your lordship, my lord. Here, my lord, I filed an application before the Chief Secretary, Odisha, for giving the list of emergency victims who were arrested at the time of emergency, my lord. After receiving, my lord, after receiving that representation, my lord, the Chief Secretary of Odisha, without giving the answer, only the financial department give the answer. That is page 32, my lord. Kindly see, my lord. Page 32, my lord.
Same petition, Mr. Chitranjan Mohanty is already, after I took over, I think this is the 4th or 5th petition of the same.
No, my lord. This is the second, my lord. Second, my lord. Previous writ application, my lord. Your lordships kindly see, my lord. Previous writ application, the order of the previous writ application.
My lord, his grievance has been properly addressed by the finance department. He is saying that Chief Secretary should have. Chief Secretary is the head of all the departments, and the concerned department has answered you. Is it not more specific?
My lord, concerned department is the Chief Secretary, not the financial department. My lord, I want to.
No, no,
Chief Secretary is the head of the finance department.
no, is the head of the finance department, but according to the list, I want to list of the victims, my lord, who are the arrested. Not I am giving for any financial benefit, my lord. I want to list, my lord. So my only grievance is the chief secretary
Where is
should.
your representation? After the last order, where is your representation?
My lord, that is page 17, my lord. And the postal receipt is, my lord, page 17 to 19.
My lord, his representation was considered and it was answered
Considered by the wrong authority, my lord. My lord,
Wrong authority, how can you say?
my lord,
That he is the
financial
finance
department.
secretary and chief secretary is over and above the
Where is the chief secretary's order?
My lord, chief
page
secretary
32.
has it.
Page 32. That is the order of
No,
the
no,
finance
that is the
secretary.
financial department.
That is the
not the chief secretary.
answer to his representation. Hence, it is not possible to consider and is hereby rejected. He has answered
So,
it.
my lord, here my humble submission before your lordships, my lord. Only chief secretary should give the answer, my lord. If financial department is not the appropriate authority, my lord.
Hypothetical, my lord.
Then hypothetical.
That is government. Government
No,
is
no,
giving you the answer.
No, no, government. Here, my lord.
This is the second round of litigation concerning the petitioner's demand that he should be provided with a list of political prisoners of emergency. Full stop. Pursuant to the order passed with this court on 13 July 2022. That's 13 July. Oh, this is the third petition, sir.
Well, that is third petition.
Now slowly we.
Now, previously was
earlier you said second petition. This is the third petition.
Sorry, my lord. That is third petition. Sorry, I am extremely sorry.
Right at the beginning, you said this is the third petition concerning the petitioner's demand for being furnished with a list of political prisoners held during emergency. Stop. Pursuant to the first order dated 13 July of 22 of this court in writ petition civil PIL number 6930 of 2020. And further to the order dated 21st September 2022 of this court in writ petition civil 18205 2022. The petitioner made a fresh representation to the chief secretary on 10/11/2022. So, pursuant to the above representation, a reply was sent to the petitioner on 30th November 2022 by the Finance Department as follows. Take from page 32 that 1 and 2. Paragraph counsel, the petitioner insists that since the representation was made to the chief secretary, it is he alone who can reply to the representation and not the finance department. Full stop, the court is unable to agree. The concerned department in the government, which is actually handling the issue, has to answer, and which is what has happened in the present case. Paragraph, if in fact there is no scheme of assistance, the court cannot issue a mandamus in that regard. The court is not inclined to grant a new straight for the petitions dismissed.
My lord, can I pray, my lord? My lord, can I pray, my lord? One thing, my lord. Representation may be considered by the only chief secretary, my lord.
I have rejected that.
My lord, because
already
my lord, because my lord, the victims are facing medical treatment, my lord, are facing only to benefit the medical benefit. They wants to medical.
So many schemes, sir. Find out about other schemes and apply under that.
But here, my lord, financial department is not the appropriate authority. That is my only grievance.
All right.
Can I file the fresh application, my lord?
Just call out.
Item 31.
Lordship, here, Lordship, the petitioners, the villagers have been submerged due to land acquisition for a irrigation project, Lordship. Lordship, kindly see page.
Which year?
Lordship, page 40, Lordship, kindly see. 40, it has been directed to the collector Kalahandi, Lordship, by the RDC, additional secretary. It is just to be taken a decision, Lordship. The minimum amenities, Lordship, electricity and the residential house has to be provided under the scheme, Lordship.
All right. A direction is issued to the collector Kalahandi to act on the letter dated 1st October 2022, sent by the Revenue Divisional Commissioner, Southern Division, Barampur, to the Collector Kalahandi regarding grievance petition of the present petitioners. After giving them a hearing, not later than 1st May 2023, and communicate to them the decision within a week thereafter. The court clarifies it is not expressed in any matter.
Item note 32.
May I please, Your Lordship? Lordship, this is a PIL, my lord. The petitioner is a resident of Bhanjanagar in Ganjam district, my lord.
My lord, this is a typical allegation made by the petitioner. He is saying that both highest bidder and the second bidder, they colluded themselves and he gave a higher
How is
price.
this a PIL? Why is it coming for us?
No, he's a public. He is saying that there is a loss of revenue. If your lordship, I will seek instruction from this, because he is saying that there is they have colluded each other. This first.
Where are they? They're not made parties.
Oh yes,
My lord, I have made them parties, my lord.
Where? Come to page.
My lord, I opposite party number 5, my lord. He is the
Which is
the Tahsildar opposite
you're
party.
appearing in 4638 or is some other petition?
I am appearing in WPC number 4638 of 2020.
Just turn to page 2 of the cost title, sir. 1 and 2.
My lords, I have made Ashwini Kumar Acharya. He is the Tahsildar has selected him as the
1 minute, just show one. I think we have a different petition. What is this? What is that? Oh, oh. All right. Counsel for the additional government, Mr. D.K. Mantri Leonard, AGA, 6 time for instructions. At his request, list on.
I'll file counter.
my lord, I have filed an IE, my lord, seeking a direction to the opposite party number 4, the Tahsildar, not to execute the lease deed, my lord, until the matter get listed.
All right, just say notice, he accepts notice. For 1 to 4, notice will now go to opposite party number 5.
Yes, my lord, opposite party number 5.
What with the other man? There are 2 persons who are in collusion.
My lord, the Tahsildar has selected this opposite party number 5 as the highest bidder.
All right. Notice to 5 by registered speed post returnable on the next date. The replies be filed within 4 weeks, rejoined of service, rejoined before the next date.
My
The
lord,
next day, there should be no execution of the lease deed by the Tahsildar. List on. Fifth April.
grateful, my lord.
Item note 33.
My lord, 33, 34, 42 assessment order has been challenged. I may be permitted to file appeal now.
All right. Counsel petitioner seeks leave to withdraw the present petitions with liberty to file an appeal in accordance with law. Such appeal is filed not later than 24th April, accompanied by an application for not 24th April, sorry, 20th March, accompanied by an application for continuation of delay, explaining the delay on account of the pendency of the present petition will be considered by the appellate authority in accordance with law. The court clarifies it is not expressed in use of matter.
Order of assessment may kindly be returned, my lord.
Yeah, originals be returned.
Obligement.
Item note 35.
May I please, my lords, these matters covered by your lordships are the earlier order, my lord. I've given a copy relating to return of originals which have been seized. I've made the necessary corrections, my lord. And so far as the counter is concerned, my lord, they still take the same stand that the document shall be returned after issuance of show cause notice.
All right. Same order.
Same order.
I've already filed my wakalat now.
All right.
Obliged, my lords.
Item 36.
36 my lord, that IBC matter. And
when is it coming up, sir?
Sir, my lord, it is coming on 8th of May.
All right. Same order.
The judgment recently I came across 2 to 3 days back of Delhi High Court by Rajiv Sakdar. Just it's a wonderful judgment. I'll bring on that day.
All right. All right. Yes.
Item 37.
May I please, your lords? The second round litigation of this paper is this honorable court, my lord. Annexure 2, my lord. The lordship has directed if the department chooses to issue a fresh notice in compliance with the ITJ section instruction 11 May 2022
then in such event, the right of the petitioner to challenge the press notice it in accordance with the law on all the grounds available to the petition in law is reserved. When this writ petition disposed of on 11/7/2022, my lord, prior to this, they have issued notice 148 AB on 25/5/2022. That is annexure 1. After disposal of these things, they have not issued 148 AB once again. They have issued a direct 148 AD and at the same time 148. So there is no occasion to call for the documents as prescribed as per the instructions issued by the CBDT.
Reserve all the appeals.
These are
covered, your lordship,
the
edition I have filed.
In this connection, this is similar matter decided by
Receive metallics and other cases, lordship. Recent order of your lordship where it will to raise all these
All the
things at
fees at the appropriate stage. All right. Same order. All right.
And a similar order I have already given, my lord. That is in my case now.
After that, lordship passed that order, CNC metallics and other.
I can have given this order, my lord.
The one I showed you. That's
Your lordship are similar matter. Paragraph 3.
All right. Take this Kalinga hatchery itself. Same order. All right.
Item 38.
Please, lordships. As you will kindly see, Annexure 2 at page 22, an order of assessment was passed for the period 1/4/2013 to 31st of March 2015, against which I approached before this honorable court in WPC number 19132 of 2016. Annexure 3 at page 30. My lords disposed of the writ petition by saying that you file appeal, and so far as the ITC is concerned, you pay the pre-deposit by keeping aside the ITC. We are of the considered page 33. We are of the considered view that these issues can be raised in an appeal. But Mr. Poti, learned counsel, submits that in that case, he would be required to pay the statutory pre-deposit on the entire demand. Considering the submissions made, we grant liberty to the petitioner to file a statutory appeal before the appropriate forum within a period of 4 weeks from today. However, we also make it clear that the statutory pre-deposit shall be computed without making any account taking into account the input tax credit disallowance and other interest and penalties thereon into consideration. Then, my lords, the appellate authority, he disposed of by the Annexure 5, page 37, and he said he reduced it to 70, gave relief of 74 lakhs. Annexure 5 to Annexure 5, my lords, may kindly say page 37. The against which, my lords, that balance 22 lakhs or some odd, I preferred a second appeal. Lords will kindly see second appeal with courier received is Annexure 6 at page 45, my lords. Now the department, on the assumption that I have not filed any second appeal, has issued this notice Annexure 1 at page 20 that you pay the entire amount.
You want to seek instructions? Well, all right. Notice, he accepts notice. Till the next date, no coercive steps shall be taken.
My lords.
Reply we filed within 8 weeks, joined of the next date. This on
March, my lords.
Why?
March will be.
Stays there.
After first week of August, there will be no sell tax.
No. What do you mean?
Madam, West is over. That is over.
Keep Justice Raman busy. Right. 16th August.
16th. Well, too far, my lord.
No. It's all right.
Item 39.
Item 39 and 40, my lord.
Yes.
Notice is more than 6 years.
Yes.
And the similar order already.
All right.
Is pending before the Honorable Apex Court.
That's it. No stay granted. All right. Same order.
Item 40.
This whole Ambika IN is now in the Supreme Court.
Yes, madam.
These
are pending before the Honorable Apex Court. And
correct.
In both the matters,
39 and 40. This is 41 already. Item number 42.
Item 40, my lord.
Item
39, 39, 40 both same.
Yeah.
Item 42.
42 and 43 TCS matter. I've corrected the names. Not
all right.
Stop names.
Same order. Same order.
Item 43.
No, 42, 43, both is the
same. Not 42, 43. Two matters.
Item 44.
44 no instruction.
No instructions.
With liberty, if
Item number 45.
None of this.
Item 46.
Item 46 and 47, my lord, kindly be taken up after lunch, my lord. Some
Just
difficult.
pass it over. All right.
My lord.
Okay. Item 48.
Pardon, my lord. 45.
But
no instruction from client side.
And then 48?
48 also.
Both 45, 48, no instructions. All right. Withdrawal memo. In 48, you say withdrawal memo is taken under.
I am for the respondent, my lord.
All right.
I am for the petitioner.
All right.
Good. Item 49.
49.
माय लॉर्ड आई एम 49 और मैं थोड़ा हिंदी में बोलने के लिए रिक्वेस्ट करता हूँ।
इजाजत दे दिया है।
और सर वो लैक ऑफ एक्सपीरियंस नहीं है, इसके लिए जो भी है थोड़ा
लैक ऑफ एक्सपीरियंस नहीं है सर, एक्सपीरियंस है।
हाँ सर, थोड़ा
लैक ऑफ एक्सपीरियंस नहीं है तो एक्सपीरियंस है।
सर थोड़ा जो गलती हो जाएगा थोड़ा माफ कर दीजिए।
माफ कर दिया है। हाँ
सर, हमारा जो एक केस नंबर हम रीट अपील लाया है वो 1412/2022 उस पे जो ऑर्डर पास किया गया है माय लॉर्ड, काइंडली द सीरियल नंबर 6 फ्रॉम द ऑर्डर। सर, लॉ काउंसिल फॉर द स्टेट सबमिटेड द सील कवर बिफोर दिस कोर्ट and it was found that the petition is disqualified because of his score only 47.75, which is far below. My lord, मेरा रिक्वेस्ट ये है कि ये जो 47.5 है अकॉर्डिंग टू एडवर्टाइजमेंट दैट इज क्वालिफाइंग मार्क इज 43 इन दिस सेड एग्जामिनेशन।
क्वालिफाइंग इज डिफरेंट फ्रॉम कट ऑफ सर। कट ऑफ का मतलब क्या है पता है आपको?
सर कट ऑफ मेरे को पता है, लेकिन एक सिमिलर ऑर्डर है सर एक केस में, वो है हमारा 701/2019। इन दिस केस ये हुआ है मैम, ये सॉरी माय लॉर्ड, ये हुआ है जे अगर पोस्ट हमारा वैकेंट है, सेड एडवर्टाइजमेंट में पोस्ट वैकेंट है, तो उसी से, और ये सर ये जो टीचर एलिजिबिलिटी है ये हम तीनों क्वालिफिकेशन आई हम क्वालिफाइड।
सर कट ऑफ का मतलब है दे फिक्स अ सर्टेन स्टैंडर्ड।
हाँ, सर्टेन स्टैंडर्ड।
हाँ, इफ यू डोंट मीट दैट स्टैंडर्ड merely because there are vacancies, we can't change the cut off.
Sir, vacancies are available for a similar.
That's right, sir. Vacancies may be available. They can fix a cut off. They can say that we want people with a minimum of this standard.
No, sir. Exactly, another thing is happened in the writ appeal case number 701/2019. There is a similar order that.
Sure.
That matter 701 of 2019 and other batch cases relating to that Shiksha Sahak matters, and they were having the benefit of age relaxation by virtue of the order of the Honorable Single Judge, and the writ petition was disposed of because of non-general party, so they approached this Honorable Court in the writ appeal, and the in course of hearing of the writ appeal, this honorable court taking a liberal view that they were extended the benefit of age relaxation and only for the technical reason of a non-general party their writ petition were disposed of, this benefit was granted. That order was been passed. That case I was arguing matter. All the 701 matter, 702, and this matter
There they say you adjust them against existing vacancy.
No, that Shiksha Sag matter. Here the contractual teacher matter, sir.
I don't know. So here what he's saying is, in that case for Shiksha Sahayaks, if you could take more people against vacancies, why can't you do it for even trained teachers?
Vacancies were available in that case.
Here also vacancies are available.
We have already completed 2 more selections of the order of the advertisement.
Sir.
August 2021 there was advertisement. 2 selection processes are already over.
ट्रेन का जर्नी खत्म हो गया है
सर नहीं सर ये जो बोल रहे हैं एडवर्टाइजमेंट और दे दिए ये सिमिलर केस में भी उसके बाद भी एडवर्टाइजमेंट हुआ था सर उसके बाद भी एडवर्टाइजमेंट हुआ था सर उसके बाद एडवर्टाइजमेंट हुआ था उसके बाद इनको दिया गया है सर हाँ और सर आई हैव ऑलरेडी इन माय आरटीआई एप्लीकेशन आई हैव so many posts are laying vacant. There is so much posts are laying vacant, sir. Or I am qualified 3 exam, BED, OSCET and CBT also.
Right.
So who he is refused, but similar case, some benefits are given by the court. Or we are also overage candidates, my lord. We are all are overage candidates.
That's the added problem, sir. That's the added problem.
Sir, it is totally illegally. Sir, same matter, sir. Totally same matter.
We don't agree, sir. We don't agree.
Sir, one thing is, sir, kindly request me to give another date because I am filed some RTI matters and within 3 or 4 days, maximum 5 days, it will be come.
All right, sir. All right.
Please give me another date.
All right. The appellant who appears in person wants an adjournment to produce some more documents in support of his case. That is request list or $9.
Item number 50.
Item 50 में pleases your lordship on behalf of Mr. Senior Advocate Ashok Kumar Mahanti Millard, pray for Thursday, your lordship. Due to personal inconvenience, he is out of station Millard. Thursday, your lordship.
Bail, interim bail.
Yes, your lordship.
193 of 2022. 1 minute. Notice is already gone in this.
Paper is also ready, my lord. I am appearing on behalf of the informant. Ready for hearing.
Hearing means then it goes before the regular bench. Why is it coming for us?
Yes, your lordship. Yes, your lordship.
This is not a parted appeal.
Flag F, something there. There is a flag F.
What is flag H?
No, so I don't know. I will pay a lawsuit to peruse it because there is
that's simply a report from the conditions of release. This is
Then it is ready for hearing. Ready for hearing.
This is not a part-heard appeal. List before the roster bench. On 13th March.
Okay.
Item 51.
My lord, 51. First, ITA 78 of 207 may kindly taken up.
Who's for the BDA?
Mr. Mahapatra is.
Where is he? He's not aware of restoration, sir. You have to, probably he's not aware of the restoration. It's now a restored appeal. It was dismissed for non-prosecution. So you better let him know, sir. Mr. Dayananda Mahapatra appears for the Bhubaneswar Development Authority. If not already served, a complete set of the paper book be served on him.
No, I've always given.
Another copy you can.
He has to file rejoinder.
Another copy you can.
Appeal, sir. Where's rejoinder or not? No question of rejoinder. 'List on 8th August.
Item number 52. Matter related to Sishu Bhavan, a committee constituted by Lordship. Two report has been placed before the Lordship. On 14/12/2021, this committee placed a report. To that effect, they reply to that affidavit. To that effect, some portion has been modified and some are still pending. And again, this committee visited the on 19/7/2022. They placed the report. Thereafter, time and again they take adjournment regarding the compliance of the affidavit.
Going on, this construction is going on and on and on. New Sishu Bhavan.
That is going on.
Endlessly.
Yeah, there is a huge construction. Lordship may
Whatever,
imagine
sir. I think the deadlines have been going on, getting postponed. At least last 2 years, it's been on. No? You find out when is the new building at least going to be opened.
But multi.
Then all these problems will get resolved.
Yes, madam.
Everything we have placed on record in November 2021 when we
Where is your
visited.
affidavit? Where is
My lord. 14/12/2021, my lord.
No. 21. Can't be 21, sir.
19/7/2022. It is that
report that is 19/7/22 is the report.
Report.
Yes. Additional
What we
report.
need to do in terms of the last order?
Last order they take time just for the personal difficulty. On Lordship kindly see order number 36.
No. Last order is in order number 35 dated 19/7/2022. 19/7.
Before that, there is an order. We have complied the
first report.
No, 19/7 order.
That I know that Mr. Samantray was not present, and very unfortunately, he is also today not present. He has gone to Jharkhand. Anyway, I'll appear with
My lord, I want to submit before your lordship. 19/7 order has not yet been complied.
19/7.
19/7 July.
Corrective action was to be taken.
That affidavit is at flag 10 of your lordship's brief line. That has not been complied with.
2852.
My lord, cause of action arises and issue survives.
Correct. On 19 July 2022, Mr. Samantray had undertaken that the report submitted for the Advocates Committee would be examined.
My lord.
Additional
and
report,
corrective action would be taken. Full stop. Mr. Mohanty learned counsel petitioner and Mr. Vidya appearing in person point out that in the connected matter, point out that
Yes, my lord, I got that order. We have to file that traffic. Lordship,
the said order has not yet been complied with. Paragraph Mr. D.K. Mohanty states that Mr. Samantray, who usually appears is in some personal difficulty today. He assures the court that an affidavit by way of compliance with the above order dated 19 July 2022 will be filed on or before 15th March 2023 with advance copy to counsels to the petitioners who are permitted to respond thereto for the next date. 5th April.
5th April, yes. Oblige.
That is additional report, madam.
That is
oblige.
Comply the order.
Item 53. Oblige. Item number 53.
53.
No, please.
Item 54.
Item 54, my lord, kindly have a glance to my lord's order dated 15/11/2022, my lords. That my lord, government was required to file an affidavit.
54. Yes, madam.
Patakamunda forest.
Patakamunda forest, my lords, that what my lord, the allegation is that my lords, the village my lords is within that forest area. The forest works as a natural barrier, so not to allow the elephant to enter into and to destroy this. The other part of the villagers, they are cutting up, falling out the trees and taking out the trees and selling out. They are destroying the trees. That is what matters. What happened? Government has made an instruction to make a village level committee so as to monitor and guard it.
You want to comply with this order by the order dated 22nd August 2022. And no, at the hearing of the matter on 22nd August 2022, Mr. Manti Learned AG had undertaken that a further affidavit will be filed stating the steps taken to constitute
In
the
terms
village
of the order dated 22nd August.
surveillance committee. Stop. Mr. Manti seeks and is granted 4 more weeks' time to comply with the above order. The affidavit will be filed at least 1 week prior to the next date with an advance copy to constitute the petitioner. Thirteenth April.
My lord, 13th April. Item 55.
My lords, I'm appearing on behalf of Miss S. Panda in the lead matter. I'm seeking a short accommodation of 4 weeks on account of her marriage. In WPC 5659 of 2021. Also, my lords, I would like to point out, as per the last order, we haven't yet received the affidavit which was supposed to be filed by the union. We have not received it from the registry either. I do not have any information whether it has been located by the registry. As per order dated 27/10/2022.
Counsel to the petitioner states that in terms of the order dated 27/10/2022, the petitioner is yet to receive a copy of the counter affidavit filed by the opposite party government of India. So if not already served, a copy thereof should be served on counsel to the petitioners within 1 week from today.
We have already filed our counter, my lord. We have completed.
Serving a copy, they want a copy to be served.
You, my lord.
In respect of other case, another case.
Also, if my lords may please grant us time of 4 weeks, I would be obliged.
27 June.
Obliged, my lords.
Item number 56. May I please, my lords? First, this is a case. Your lordship was pleased to issue notice in this case on 12/1/2016, lords, and directed interim protection to this petitioner. Copy has already been served. My lords may kindly turn to my lords annexure 4 at page 37, my lords.
Yes.
This is an order of assessment under section 42. If my lords will kindly turn to page 39, my lords. Page 39, second paragraph. In the assessment order passed today under the CST Act for the period 1/4/2012 to 31/3/2014, claim of exemption from tax under section 5(3) of the CST Act on sale of iron ore fines amounting to 14 crores so and so has been disallowed since the assessee could not substantiate the penultimate sale claim, and it was for the purpose of complying with the agreement or order that the exporter had or relation to export. Such sales have been treated as local sales under the OBA Act, excise tax of 5%. Further, the turnover of such sales amounting to 14 crores so and so have been deducted from the turnover of the CST Act. Now the said amount is added to the gross as well as taxable turnover under the OBA Act. One line I am reading only. Although the tax audit has suggested disallowance of exemption from tax on a portion of the sales, yet on careful examination, the exemption claimed under 5(3) of the CST Act on the total sales of 14 crores has been disallowed. Now, my lords, this amount, 14 crore, has been deducted from the CST Act and added to the OBA Act. Now, this is a writ petition arising out of this OBA order. So, for a CST order, I was also before Lordship Mirrors. Your Lordship relegated me to approach the appellate authority. Now, the appellate authority, in the meantime, Whereas the CST Act, the challenge was with this 14 crore bills. That has been dealt in by the appellate authority. In the assessment, I have given to a lordship bills order of assessment as well as bills this appellate order. My lords may kindly see this has already been dealt in. Your lords may kindly see the assessment order, my lord, for a moment. Assessment order, page 45, my lords. Last paragraph, my lords may kindly see. Last 2 lines. Last one. Exemption from tax claimed under section 5 of CST Act on page 45 means, in the top it is mentioned 45. There is no internal paging of the order. There is mentioned page 45. Order of assessment, yours.
No, it's a compilation on paper book.
The compilation at the top it is mentioned 45. There is no, yes.
Right, right.
That's the last 2 lines, my lords. Exemption from tax claimed under section 5(3) of the CST Act on sales amounting to 14 crores 84 lakhs. Same amount is disallowed, deducted from the turnover under CST Act and added to the taxable turnover under the OVA Act for the period so and so. This demand is challenged and the appellate authority now has already decided in the next document which I have filed at the appellate order, my lords may kindly see page 13, my lords. This appellate order is numbered now. Page 13. Then 13, the findings, and let me take my lord's attention to the last paragraph. At page 16, in the result, appeal is allowed. Assessment order set aside with an instruction to an assessing officer to complete reassessment of the instant dealer afresh on the basis of above observation within a period of 4 months from the date of receipt. My humble submission is this order of assessment, which is order challenged by before lordship, which doesn't survive because of your lordship direction. And after relegation, the order now passed by the appellate authority. So this is liable now to be set aside. My lords.
On 23rd December 2021, in petition civil 238. Is it 268 or 238?
You have written in handwriting, you have written 268 at the top.
At the top, my lords.
Oh, today's matter is 268. In 238 of 2016 and the consequential fresh assessment order.
I have just, may I be permitted? I have been served with these orders, my lord. Let me go through this and whether any challenge has been made to the appellate order, let me.
So it's a matter of record set aside now. In my
lord, whether challenging this appeal order, whether any.
No, I have to challenge. I have not challenged. I think you don't have to challenge.
My lord, may I go through these? I have just now received what my learned senior is.
Ultimately, this doesn't survive. In any case, the order doesn't survive. The effect of this appeal order doesn't survive.
Yeah. An assessment order has been passed on 26th, on what's the date of this order? No, it could just be after this. After our order. And this already covers it. All right. You see, by the order dated 23rd December 2021. Right. Correct. You see, let's take this afresh. Against the same SSC for the period 1st April 2012 to 31st March 2014, against an assessment order dated 26 November 2015 of the Joint Commission Sales Tax Balashwar Range Balashwar. The SSC had filed a petition civil number 238 of 2016 by an order dated 23rd December 2021.
20 September, 23rd September 2022. Appeal order.
No.
So sorry,
by an order dated 23rd December 2021 of this court and petition civil 238 of 2016. The petitioner was permitted to file an appeal against the aforementioned order not later than 7th February 2022. Stop. In the said appeal on 23rd September 2022, an order has been passed setting aside the original assessment order. First of all, perusal of the original assessment order under section 12 bracket 3 of the Central Sales Tax bracket Orissa bracket rules 1957 reveals that a perusal of the appellate order. Said appellate order reveals that the appellate authority has held the assessment order under section 12 bracket 3 of the CST bracket Orissa bracket rules for the period 1st April 2012 to 31st March 2014. To be bad in law. And in that process is also observed that the assessment order impugned in the present case, which is under the OVAT Act, also to be bad in law. Paragraph in that view, the matter, the impugned order does not survive, and the present writ petition is accordingly disposed of as having been rendered infructuous.
Published matters. Item number 57.
May I please, your lords? May I please, your lords? I want some times, my lord.
Counsel for the petitioner stated to be unwell today. List of 10th August.
Item 58.
None appears to speak.
Item number 59. May it please the lordships. This is covered by Keso Automobiles. Keso Hotels was under the OVAT Act. It is under the CST Act, but the principle remains the same. Here, my lords, without any assessment, self-assessment under rule 12.1, 12.2, 12.3, the reassessment order has been passed under annexure.
Did not pass any corresponding order for.
No.
Achha. What do you say?
Directly, lordship may see the assessment order. It is totally covered.
No, the provisions are similar.
Only principle remains the same, my lords.
No, the wording is similar.
Wording is similar. Lordship will see the rules for the time being.
Yes,
CST rules 12.4. CST Orissa rules 12.4. I'm just a minute. I'll take your lordships to the wording of the sections, which reads like this. Where after a dealer is assessed under subrule 1, then bracketed 2, bracketed 3, for any period, the assessing authority on the basis of any information in his possession is of the opinion that the whole or any part of the turnover of the dealer in respect of any period or period has escaped assessment. So there is a condition precedent like OVAT Act matters. He has to be assessed. And no counter has been filed, my lords. Matter has been admitted.
Kindly see, my lord, 12.1a. May I please, my lord? The old one, my lord. It must be at the foot of the
page 12. 12-1.
12-1, the old ornamented. That will apply here. At the foot of that. May place 12-1A.
No, let's see. Yes, sir.
12-1A. After submission of declaration form and or certificates as prescribed under Rule 7A of these rules, the declaration forms and or certificates of furnish shall be scrutinized with reference to the return to which the declaration form and or certificate relate. And in cases where, my lord, may skip this I, 2I, 3I, and IV, the said returns shall be accepted as self-assessed without any further communication to the dealer filing such returns. So this is in quite contrast to the OVAT and OIT rules. Here the statute itself says that no communication is required.
But the question remains, my lords, whether I have been assessed or not. Because 12.4 says that I have to be. And secondly, my lords, about the limitation. Limitation is 5 years. Now period is 1/4/2008 to 14. And the assessment is completed in 2016. 5 years. 12.4 says that within 5 years.
As regards, my lord, limitation, my lord has exactly on this 12.4 has rendered a judgment. And that, my lord, we have carried on to the Honorable Apex Court, and that is now subject matter of this SLP, my lord, which is pending.
But I don't.
That is in SLP number.
But he cannot escape. But he cannot escape the rigor of 12.4. He has come back to the department. It's very good. Well, he cannot. Certainly, he cannot say. 12.1A is something different. That is after declaration. The question is.
Yes, my lord. After filing up return.
Yes.
Kindly.
Yes.
Then see. OBAT.
But 43 is in perimetria. He is in perimetria with 12.4.
Kindly see section 39 of the OBAT Act, my lord.
Yes. Scrutiny of return.
Yes, my lord. Here there is no such provision that there is no communication required to the dealer. Rather, on the contrary, my lord has held that no, even if you have assessed accepted his return, then you have to communicate him that it has been so accepted. Here, my lord, the statute says no communication is required to the assessee. Once he files the return, it is deemed to have been accepted, my lord.
Very good. Very good. My lords, then at least a counter should have been filed. At least for 6 years. Why the counter? You have to say that yes, I have scrutinized. And I am.
All right. Last opportunity to the state to file its reply within 8 weeks, rejoined from the next state. There's an interim order already?
Yes, yes. Interim order is there.
Interim order to continue.
And Lordship may also produce the records.
Yes, my records are with me. I will file the counter.
Yes, yes. If it is
the relevant records we produced on the next.
If he has got the records, he should have produced it earlier. Lordship may posting it to Malacca.
Let's have a fresh thinking on it. 24th August.
Oh, bless.
As your Lordship pleases.
Right.
Then
item number 60.
Sorry.
Item 60.
Only show cause notice states, sir.
Show cause notice is in Annexure 2.
You can reply, let there be an adjudication order, sir.
Adjudication under Annexure 1.
Then
take one by one point to your lordship.
No, 1 minute. Adjudication order, there's an appealable order.
It's an appealable order. It is an appealable order, but here in this case, your lordship will find what your lordship has passed an order when your lordship was there in Delhi High Court about the jurisdiction, very important point in Mangli Impex case. The jurisdiction is a very vital foundation for the purpose of adjudication. Here the very patent error that has been noticeable is from 74 lordship will see.
Which is the order of Delhi High Court?
Para 8.
Mangli Impex is still pending.
Still pending in Supreme Court, although it is indirectly been confirmed in another case. Your lordship
Mangli Impex is stayed.
Yes, Saidali was being taken proper note of it and Mangli Impex order was passed. But in Hemchand Gupta case, Mangli Impex was used and they filed in Supreme Court appeal, and that Supreme Court, while the matter is going on for hearing, they withdrew that appeal. So it is a landmark judgment.
Mangli Impex is still stayed.
Long back. Long back.
So many cases. That delegation of the power. Second order, you said Hemant Gupta or something.
Hemchand Gupta I could not get because it is a tribunal order. Your lordship know that in valuation and also in classification where liability is determinable, that will go to Supreme Court directly after the start.
Correct.
So that order went there. Here Mangli Impex was used, even Shahidul was used, and Mangli Impex was appreciated when it was going to appreciate the withdrew. But there are other two cases where Hemchand Gupta is also indirectly been approved.
I see.
But I have yet to get those orders. I could not get those orders.
All right.
Here is the same issue. I'll just speak only 2 points. Your lordship may go through 74. What the authority
The only issue is because Mangli Impex is in state. That's the only thing.
No, there are further issues on merit.
No, should we wait for Supreme Court judgment? Yes. Not his only question.
That's true. I have no difficulty. What your lordship appreciate.
Lordship, I have filed counter, but no counter has been sought to my senior lord.
Oh, I see.
So lordship, kindly keep it off 1 week after. I'm just now received the brief just now, my lord.
All right.
So our stand is not as because alternate remedy and notification which are challenge the jurisdiction. The commission have the jurisdiction. I have enclosed my counter affidavit. Lordship, have a glance that he has the jurisdiction.
Where is the jurisdiction?
Your lordship, see the counter affidavit.
Where is that? Where is it? Oh.
Your lordship, see the counter affidavit. Turning page 23. 9 June 2017.
Anyway, you say the issue arising in the present petition. No, counsel for the petitioner informs the court, submits that the issue arising in the present petition stands covered in the favor of the petitioners by the judgment of the High Court of Delhi in Mangli Impex Limited versus Union of India, 2016, 335 ENT, 605 bracket A. Full stop. The appeal against the said judgment is still pending the Supreme Court of India, which has stayed the operation of the said judgment. Paragraph. Since the outcome of that proceeding would have a direct impact as far as the present petition is concerned, the court considers it appropriate to await the judgment of the Supreme Court in the said case. The interim order will continue. Oh, there is no interim order here.
No interim order.
All right. List on. Let me see list on.
Your lordship, record that I have saw the copy of the contract.
As your lordship will be hearing at a later date, so let me be under protection, at least there shall be no recovery further.
Are they taking steps?
They have taken and we have paid the whole money, but this only arbitrated demand only, they are now pressing for payment.
No, they're pressing means what? I mean, have they sent some notice or something? You file an IS if there's something like that.
Obliged, my lord.
Ha. List on 5th September.
Item 61. 61, my lords. My lords, this repetition can be disposed of on a short ground, my lords, and it is covered by your lordship's order. Lordship may see the Sokas Annexer 1, page 19, was given on 22nd of April, and to give the reply on 22nd. Lordship will see this starts Annexer 1, page 19, and your lordship will see file your written reply objecting to the proposed modification. It may, in case no response is by 23rd, I have to give the reply. And the assessment order was passed on Annexer 2 on 23rd. This is the short ground. Instead of this screenshot, I am giving my lords a list of judgments for your lordship's kind perusal. Lordship will see in से जो शाश्वती पंडा केसटा देखिले Sasmita Panda, my lords, page 2 to 5. Lordship set aside the order of assessment. I am not on any other ground. Draft assessment order, screenshot, whether notice was issued, short ground, my lords. I have to save myself.
What do you say?
Is it taken?
On the last occasion, your lordship.
I am not pressing it. Arey, what a muskil. I am not pressing it. I am not pressing the ground, but still then you are
you're ambushing him. You're ambushing him. Suddenly, you're producing this whole thing and changing your tactic. Yes,
that is the short duration. Lordship passed the order, as I find.
Arey Baba, I am not pressing that. You have given this eye shot, screenshot.
No. That in that cited judgment, page 4, what my Lord Senior has submitted.
Yes, same thing. Only one day.
That is the short duration based on which
yes.
Has been passed.
So we'll set it aside on that. All right. It is seen from the impugned order of the National Faceless Assessment Center, dated 21st April 2021 for the assessment year 2018-19, that only 1 day's time was granted to the no, 23rd, order date 23rd, that only 1 day's time was granted. Only 2 days time was, no, 1 day's time was granted.
1 day's time.
By the show cause notice dated 21st April 2021. That is, the assessee was asked to respond by 23:59 hours of 22nd April 2021. In similar circumstances, this court has made its order dated 27th April 2022 in Writ Petition Civil 10213 of 2022, bracket Sasmita Panda versus ITO, National Faceless Assessment Center, Delhi. Set aside the impugned assessment order and the consequent demand notice. Accordingly, in the present case, the impugned assessment order dated 23rd April 2022, bracket Annexure 2 and the consequential demand notice bracket annexation 2 capital A are hereby set aside. So this will not prevent the department from proceeding in accordance with law hereafter.
Much obliged. Item 62.
May I please, my lords?
Yes.
So in this case, before I take your lordship's attention to the brief, my lords, may kindly see the index, my lords. Your lordship will find because there are 3 so-called notices. My lords, of course, was pleased to, my lords, of late by order dated 10/1/2022, while issuing notices, directed that no adjudication shall be final without leave of the court. But in any case, if your lordship will see, Annexure 2 is the so-called notice dated 24/4/2017.
Right.
Annexure 4, your lordship will find, and this is for the period 2012-13 to 2016-17. Annexure 4 is the so-called notice dated 8/11/2019. This is for 2014-15 to 16-17. This is covered by the first so-called notice. Third so-called notice, your lordship will find dated 11/10/2021, for which the connected petition I have filed, minors. That is for period 2016-17. And your lordship will find, so for the last so-called is concerned, only the period left out is 1/1/17 to 31/3/17, because the first so-called notice 16-17 covers up to December 16. Now the question arises for lordship is whether there can be multiple so-called notices for the same period. I have annexed, minors, a master circular and also judgment of the Honorable Apex Court and your lordship judgment. And also, so far the case is concerned, all these so-called notices are under proviso to section 71, which provides for invoking extended period of limitation. And extended period of limitation, your lordship knows, is only when there is fraud, willful misstatement. Those are the cases where the collusion and now your lordship may kindly see the source. If it is in public domain, my lords have held, this cannot be either fraud, collusion, all that. First so-called notice, I bring it lordship notice, my lords. Annexure 2 at page, my lords, 20, my lords.
No, can we not say that they'll only go by the show cause notices 1 and 3 and not other show cause notices? Because
now that, so far as first show cause notice is concerned, my lords, I have already faced adjudication. Against adjudication, I have preferred appeal, my lords. Appeal is now set aside. So therefore, this covers the other 2. This covers the other 2, a bearing 1/1/17 to 31/3/17.
So the first 2 petitions are infructuous. I mean, first petition is infructuous.
There are only 2.
There are 2 petitions. I'm saying the first petition will become infructuous then.
No. First petition you are also already disposed of. Oh, this so-called notice 24/4/2017, that was challenged in a different petition, which your lordship have already disposed of. I have faced adjudication, and against adjudication, appeal was also
so anyway, this 35279 goes.
Now, in this writ petition, your lordship is concerned with second show cause. And in the connected writ petition, your lordship is concerned with the last show cause.
I know. So the second show cause anyway doesn't survive.
Doesn't survive, right?
So anyway, the first writ petition goes.
My lords, correct. Correct.
All right.
So may I take your lordship in judgment, lords? So your judgment, lords, I have given. There are so many judgments. I have just given a few. Nizam Sugar and Simplex, all these. Nizam's para 9 mirrors. Simplex says there cannot be multiple assessments for the same period. Para 9 of Nizam's case mirrors. And even mirrors, your lordship's judgment in Honorable Delhi High Court in the case of Roma Henry Security mirrors. Also, I rely upon para 2, 26 and 28 mirrors. My lords have delivered the judgment mirrors. Then Joybalai Jyoti very recently my lords have held that form 26. The essence of the allegation is that these are available in form 826 lords, which is in the public domain, and that doesn't reconcile with the information you have given written in form 3B lords. All 3 are same source. That is why.
Anyway, you see, writ petition civil 35279. So the challenge in the present writ petition is to show cause notice dated 8 November 2019, issued by the Additional Commissioner GST and Central Excise Bhubaneswar Commissionerate for the period 2014-15 to 2016-17. It is pointed out that in respect of this very period, there was an earlier writ petition, is it?
Earlier writ petition, my lords.
Where is that number and all? Where do you get it?
9646 of 2017.
Earlier writ petition civil 9646 of 2017, which was disposed of this court, relegating the petitioner to the remedy of an appeal.
No, to the adjudicating authority.
Right, to the adjudication authority. Right.
Sorry, appeal.
Appeal, no? Relegating the
appeal
to the remedy of an appeal against the adjudication order. Consequent upon the show cause notice issued covering the same period. And in the said appeal, the petitioner has already succeeded.
Set aside, my lords.
Yeah, succeeded with the adjudication order having been set aside. Full stop. In that view of the matter, the present writ petition has become infructuous and is disposed of as such. Then the second writ petition 35380 of 2021. The present writ petition is directed against a show cause notice dated 11/10/2021, issued by the Additional Commissioner GST and Central Excise Bhubaneswar Commissionerate for the period 1st January to 31st March.
Last show cause is
for the year 2016.
2016-17, yes.
Right. Full stop.
But the first one is up to December 16. So 3 months are left out.
Right. As far as for the period up to 31st December 2016 is concerned, it stands covered by the appellate order passed in favor of the SSC, setting aside an adjudication order up to that period, pursuant to the order passed by this court in writ petition civil that earlier writ petitions. Paragraph. In that event, in the present writ petition, we are concerned with the impugned show cause notice only for a period of 3 months, from 1st January 2017 to 31st March 2017. Paragraph. Mr. Sahu, learned senior counsel for the petitioner, has relied on. No, inasmuch as the reopening of the impugned show cause notice seeks to
Joy Balaji, para 2 and 3, lords. Then Duncan is 1, 2, 3, 4, 6th page.
No. Here the corresponding 1 minute. For the service tax, you have to see this, right?
Yes.
That is 11A. So this is the corresponding provision of the service
Simplex.
tax for the Finance Act.
Para 7, lords. Para 71 of Simplex judgment. Calcutta High Court. Para 7-1.
Seeks to invoke sections 67, 68 bracket 1 and 70 of the Finance Act 1994. Read with Rule 7 of the Service Tax Rules 1994. The judgment of the Calcutta High Court. In Simplex Infrastructures Limited versus Commission of Service Tax, Calcutta 2016, 93 VST 10 bracket KOL bracket is relied upon. Which holds that for the, but here is there an overlap for these 3 months? There's no overlap.
Only for these 3 months, there is no overlap. But rest of it, there is an overlap.
To the effect that there cannot be multiple show cause notices for the same period. Full stop. Paragraph. In that view of the matter, the impugned show cause notice, to the extent it covers the period up to 31st December 2016, is quashed. In effect, therefore, the adjudication order will now be confined to the period 1st January 2017 to 31st March 2017. Full stop. You already filed a reply to the show cause notice.
Yes.
Preliminary reply.
The petitioner stated to have already filed a preliminary reply to the impugned show cause notice. Full stop. The final reply confined to the above period will be filed not later than 1st May 2023. The adjudication will then proceed and an order will be passed by the adjudicating authority within a period of 3 months thereafter. Full stop. It will be open to the petitioner, if agreed by such order, to seek appropriate remedies in accordance with law.
Both the replacement disposed of.
Yeah. First one is already, this is also disposed of in the above terms. All right.
Item number 63. Item 63, TCS matter.
All right. Same order. The correct.
Item number 64.
My lord, become infructuous, my lord.
Infructuous dismissed.
Item 65.
65, may I please, my lord? The issue for consideration here is already covered. I have passed those orders. Also, I've taken the liberty also to propose the changes, my lord. Similar orders be passed.
Where is it, sir? All right. Sir. All right.
Grateful.
Item 66.
None of this.
Item number 67.
None of this.
Item 68. 68 with regard to short supply of country spirit by the Orissa Beverage Corporation.
Same order. Made the changes.
Yes. 69 not pressed.
Not pressed. Dismissed is not pressed.
Item 70.
Lordship, item 70 has become infructuous.
Dismissed is infructuous. All right.
Item 71.
May I please? I prepared a short reports, my lord. In this matter, my lord, for annexure 2 of the writ petition, my lord, that is stated 11/8/2017, my lord, covering the period 2004 to 2006 original show cause notice issued on 24/4/2007. After lapse of 10 years, they have issued a notice for adjudication matter. And against this have Annexure 3 have represented to the authority as a preliminary issue how you will move after 10 years by crossing the limitation period. Thereafter another reminder also. Then they have not acted anything, they proceeded. For which approach this honorable court, and this honorable court has admitted the matter and stayed the proceedings. And in this background, my lord, they have already filed their counter.
What do
In
they
the
say in
counter,
that?
the only point raised before my lords, that is at para 11, my lord. No limitation has been prescribed to initiate adjudication proceeding. Hence, the opposite parties have started adjudication proceeding. Hence, the notice has been issued for a personal hearing and asked for
There must be some reasonable
explanation
time,
as
sir.
regards to
Even if limitation is not prescribed, it has to be within reasonable time. 10 years is unreasonable time.
Madam.
All right. The challenge in the present petition is to an impugned notice dated 24/4/2007, bracket Annexure 1, and a letter dated 11th August 2017, bracket Annexure 2, on the ground that it is violative of Section 11 capital A, bracket 2 capital A of the Central Excise Act 1944, bracket CE Act. Paragraph. The background facts are that the petitioner is a partnership firm which holds a service tax registration and is engaged in the business of steamer agency and cargo handling services. Full stop. Alleging that the petitioner availed SENVAT credit irregularly for the period 1st October 2004 to 31st March 2006 on input services meant to be exclusively used for providing output services. A notice dated 24th April 2007 was issued by the department. Full stop. According to the petitioner, this was not proceeded with thereafter. After a lapse of over 10 years, a notice dated 11th August 2017 was issued, calling upon the petitioner to participate in the adjudication proceedings. Stop. The petitioner protested by letters dated 29 August 2017 and 4th September 2017. Paragraph. Thereafter, the petitioner filed the present petition. On 11th September 2017, in which on 9th October 2017, while issuing notice, this court, as an interim measure, ordered that further proceedings pursuant to the impugned SCN dated impugned notice dated 11th August 2017 shall remain in abeyance. Paragraph. In response to the reply filed, it is contended by the department that they didn't have this call book kind of system, is it?
Well,
there's some call book system, in excise and all that. They'll put it on the back burner and then take up the matter after some years.
So this is a matter not under the call book.
This is call book.
Well, that is call book. If any matter submitted before any authority, higher authority in CGAT.
No. So there is no such system here in this service tax. I see. All right. It is simply contended that since open quotation, no limitation has been prescribed to initiate adjudication proceeding, unquote. Notice has been issued for personal hearing. pursuant to the earlier SCN itself. Paragraph. The above reply is not convincing at all. Full stop. It must be noticed here that in similar circumstances, in Bhagwan Das Tolani versus BC Agarwal, 1983, 12 ELT 44 bracket Bombay. The attempt to revive an old proceeding after a gap of 11 years was disapproved and the proceedings were quashed. So in the present case, the first impugned SCN dated 24th April 2007 is itself for the period 1st April 2004 to 31st March 2006. Full stop. With the department having not taken any steps after the said notice for over 10 years, it was incumbent on the department to explain what had happened in the interim and what justified the reopening of the matter after such a long lapse of time. Full stop. There is no convincing explanation in the counter affidavit for this. Full stop. To now seek to adjudicate the SCN for the said period after a gap of over 15 years appears to be unreasonable to the court. Consequently, the impugned SCN dated 24th April 2007, as well as the hearing notice dated 11th August 2017, hereby quashed. The writ petition is allowed to give out terms.
My appearance will be noted, it has been omitted.
All right. It's noted. Appearance.
Item 72.
72 is similar matters and posted to 6th July.
6th July.
All right. Less than 6th
But
July.
in the meantime, I'll take notice to private opposite parties.
All right. The unserved private opposite parties be served in the meanwhile.
73, my lord.
They are not by registered speed post, and the tracking report shall be placed recorded next.
In item 73, notice
also there are similar matters.
Yes, but
filed by Mr. Ratha.
they have not filed counter. In my case, no counter has
No,
been
in
filed.
one case it is filed. Your Lordship may adjourn it.
This is regarding COVID fee of. They have reduced from 50% to 35%. Lordships are directed
Last
notice and
opportunity to file reply within 4 weeks, rejoined up for the next date. When is it coming up? Connect matter?
no, connected matter is there. Already is there.
No.
Other similar matters.
I don't know, Lord.
Yes,
I'm sorry.
I will ask Mr. Ratha and I will give the date.
List on. Okay.
Item number 74.
My lord, pass over, my lord, on behalf.
My lord, 74, my lord, I am there, my lord.
All right.
I am in VC, my lord.
Yes.
My lord, here notice, your lordship was pleased to send the notice, my lord, but notice could not be sought upon him. My lord, registry may be directed to obtain the status of the.
No, not returned back. That's the status. So fresh notice has to go now.
My lord.
Notice already
I'll take
issued
out-
to the
I'll take
respondent
out-
has been not returned. Fresh notice returnable by registered speed post. The tracking report will be placed to record.
Obliged.
List. September.
My lord, may I pray for early date, my lord, because
No, doesn't matter, sir. Yes.
Item 75.
May I please, my lords, that the petitioner, my lord, challenge the order of the single judge in my lord, set aside the order of termination as well as confirmed by the appellate authority and the revisional authority, my lord. My lord, opposite party happened as a constable in the CRPF, my lord, and he was been asked to submit his accident and criminal accident and cases pending against him. He disclosed that there is no case pending against him. Thereafter, matter was remanded to the collector for information. And it is found that there was a case was pending under section 436 against the opposite party. That's why taking the course of the section 5, my lord.
For punishment, it has gone back, sir.
Yes, my lord. His punishment has been that by following rule 5, my lord. He is a temporary constable. His false certificate has been disclosed false that there are no criminal case is pending. That's why by section 5 he was case and terminated. Or in appeal and review has confirmed.
Got acquitted in the criminal case.
My lord.
He got acquitted in that criminal case.
My lord, I challenge that order passed by the Lord single judge, my lord. My lord, kindly see that. My lord, that
only on quantum of punishment the single judge has interfered.
My lord, that's a but it's not a quantum, my lord. My lord, you are suppressing material fact that case.
No, sir. The single judge has interfered with the quantum of punishment.
Yes, my lord. My lord,
and simply sent it back for reconsidering the punishment.
But the rider is there, my lord. The rider, my lord, kindly see that the operating person of the order. That rider causes the difficult outcome. My lord, kindly see that order unnecessary. At page 71, my lord, all the other courts are interpreting the importance of one set aside same keep the view of the admitted suppression by the petitioner.
Tell us one thing.
What is it? Person lesser one of this limit service. This would have take a view of
Sir, I am not able to follow what you are saying. Are you able to follow what I am saying?
Yes, my lord.
That's a good development. So just come to this impugned order. What is the date?
My lord, order dated, my lord. That is 19/12/2017.
So and this writ appeal has been pending for how many years, sir, here?
For 5 years, sir.
For 5 years. Is there a stay of the impugned order?
No, my lord.
Have you implemented it?
But I have no instruction.
No instruction. By now you should have implemented it, sir. Who's for the other side? There's no other side.
I'm appearing for the other side.
So not implemented, sir.
No, not implemented.
You've given yourself a stay.
But the file contempt is pending.
Why should we interfere, sir? Just for reconsideration of the punishment. See, the impugned order, while not interfering with the finding of guilt in a disciplinary proceedings against the respondent, has only directed the appellate to reconsider the question of punishment. That was dismissal from service, is it?
Yes, below.
Removal from service.
In the last over 5 years, after the impugned judgment of the learned single judge, and during the pendency of the present writ appeal, there has been no stay of the impugned order. Full stop. The impugned order, full stop. Consequently, it is expected that the impugned order should have been complied with. Full stop. Mr. Kali Prasanna Mishral and a senior counsel informs the court that despite there being no stay granted by this court, the impugned order has not been implemented, and there is a contempt petition pending against the present appellant. Paragraph. Having heard learned counsel for the parties, you say learned counsel for the appellant and learned senior counsel for the respondent. The court is of the view that with the relief being granted with the learned single judge being in a very narrow sphere of only reconsidering the quantum of punishment, of only requiring the appellant to reconsider the quantum of punishment. It does not call for interference. Full stop.
27.
What appears to evade the learned single judge is that while the criminal case which was shown to be pending at the time that the respondent got the offer of employment ended in acquittal of the respondent. Full stop. The case itself did not involve allegations of moral turpitude. It was under sections 436, 506 read with 34 IPC arising out of a quarrel during a panchayat election. Full stop. Paragraph. In the circumstances, the court is of the view that the impugned order of the learned single judge does not call for interference. The appeal is dismissed. After lunch.
Lordship have permitted us to file written notice to commission. Yes, I'm giving one, but in Tata Steel's case, that was hard latter. So 2-3 days time I will take to. No problem. No.
Item number 76.
Item 76.
My plea, Your Lordship. Lordship, in this appeal, the prisoner is challenging the judgment dated 2/5/2018, Your Lordship. Lordship, in this case, the opposite party had not filed counter, Your Lordship, till date. And facts of the case is that in the year 2012, an advertisement was published for the post of Jogana Sahayok, Your Lordship. The petitioners with others applicant applied for the said post, Your Lordship. After that, Your Lordship, the selection committee prepare a list, Your Lordship, merit list, Your Lordship, that is annexure 3, page 17, Your Lordship. In the merit list, Your Lordship, the present petitioner stood second position, Your Lordship. And accordingly, on annexure 4, Your Lordship, final merit list was published, Your Lordship. In the final merit list also, the present petitioner stood the second position, Karbaba Biswal, Your Lordship. And one Manjushri Mahakur stood first position, Your Lordship. After this final selection, Your Lordship, Manjushri Mahakur joined in the said post, Your Lordship. And after thereafter, in the year on 31st/7/2014, she gave her resignation, Your Lordship. Therefore, the Panchayat Samiti issued a notice to the present petitioner whether he is interested to join in the said post or not, Your Lordship. Accordingly, the petitioner joined in the post, Your Lordship, had annexure 7, Your Lordship, on 19/9/2019, 2014, Your Lordship. While he was continuing in the said post, Your Lordship, the opposite party number 4 made an objection, Your Lordship, on the calculation of mark, Your Lordship. She claimed that I would be on the second position instead of the present petitioner, Your Lordship. Therefore, the Panchayat office issued a notice why you should not be giving resignation, Your Lordship. Against the said notice, Your Lordship, I prefer the writ petition, Your Lordship. And the writ petition, my writ petition was rejected, Your Lordship, on the 2 grounds, Your Lordship. First ground is that the mark calculation on subsequent date, that is correct, not on the first date, Your Lordship, first instance, Your Lordship. That is the sole ground, Your Lordship. And Your Lordship, admittedly, while the selection committee were calculating the mark at the second time, Your Lordship, they tempered the application form of the opposite party. The opposite party has submitted his application form, and the selection committee tempered the application form of the opposite party number 6. Thereafter, they made a calculation also, not in accordance with declaration given by the opposite party number 6, Your Lordship. And second thing, Your Lordship, without giving any so-called to me, without giving any opportunity of hearing to me on the subsequent calculation of mark, Your Lordship, the opposite party has issued notice to me and said that why you should not be given resignation, Your Lordship. Lordship, there is no fault of the petitioner at any point of time, Your Lordship. Annexure 1 is the advertisement, Your Lordship. Annexure 3 is the first calculation mark sheet, Your Lordship. Annexure 4 is the final selection list, Your Lordship. In the final selection list, Your Lordship, kindly see the annexure 4, page 18. The present petitioner stood second position, Your Lordship.
So you are in writ appeal.
Yes, Lordship.
You are in a writ appeal, so you have to discuss where the learned single judge has gone wrong. You're doing everything else. You're not reading the single judge's order at all.
Well, the learned single judge has
Come to page 38, sir.
Yes, Lordship. On page 38, Your Lordship, the subsequent calculation has been done by the selection committee.
So kindly read, sir.
My Lord.
You have come to page 38?
Yes, Your Lordship.
Come, kindly read now.
My Lord.
It is not in dispute. There is a fourth paragraph.
It is not in dispute that the total subject of the CHSC also inclusive of optional subjects and the total marks under the said heading each 200 and 900 each of the actual subjects. The opposite party number 6 has secured 374 out of 900 apart from the marks secured by her in the optional subject. But she has disclosed in the application form on 1100 and 413 inclusive the marks obtained in optional subject. The percentage of marks secured has come at 37.54%. This is the declaration made by the candidate herself, Your Lordship.
Read on.
Your Lordship. After resignation of Manjushree Mahakur, although the appointment has been offered to the petitioner, but it has been realized by the selection committee that there is some mistake which has been committed by the selection committee. So far as the addition of marks of opposite party number 6 is concerned, according on verification of calculation, it was found that the marks secured by her, excluding the optional marks, is 374 out of 900. Accordingly, the total percentage in CHSC comes to 41.56%. It is evident from the revised selection list that the comparison with addition of marks of the petitioner vis-a-vis opposite party number 6 done in pursuant to annexure 1, the opposite party number 6 has got weightage of 30% in class 10 at 16.96%, plus 2 at 12.47%, and plus 3 weightage of 40% at 16.77. Total comes to 46.20%. While on the other hand, petitioner weightage of class 10 comes to 19.36% in plus 2, 11.40%, and plus 3, 15.23%, which comes to 45.99%. The competent authority after
What do you have to
realizing.
say on this?
That is beyond the declaration given by the candidate, Your Lordship. Your Lordship, kindly see the application form of the candidate. I have annexed, Your Lordship. He declared, he filled up the form and gave him the declaration. Your Lordship, kindly see the annexure 10 series. The selection committee subsequently tampered her application form.
Not tampered, sir.
Yes, Your Lordship.
It's not tampering. Anyway.
It is admitted, the selection committee also admitted the said fact that
it's not tampering.
That is beyond her declaration they had taken and subsequently calculated the mark, Your Lordship.
Oh, okay. The challenge in the present appeal is to an order dated, a judgment dated 2nd May 2018, passed by the learned single judge, dismissing writ petition civil number 23133 of 2014 filed by the present appellant. Before the learned single judge, the appellant had questioned an order dated 21st November 2014, issued by the Sarpanch of the Patuapali Gram Panchayat, directing the appellant to resign from his post of Jogana Sahayak in the said GP. The background facts are that pursuant to an advertisement published by the Block Development Officer Agalpur, bracket Duduka, bracket, in Balangir district. The petitioner and the appellant and 2 others applied applications.
Pardon, Your Lordship.
Applications were made, including that of the appellant and 2 others. In the final select list, 1 Manjushri Mahakod stood in the first position, the appellant in the second, and opposite party number 6 at serial number 3, paragraph. The person in serial number 1 tendered her resignation on 31st July 2014. Thereafter, a letter was issued to the present appellant to join as Jogana Sahayak, which he did on 19th September 2014, paragraph. A letter was issued on 30th October 2014 by the BDO through the Sarpanch to prepare the merit list, the panel list chronologically. Full stop. On 21st November 2014, the impugned letter was issued to the appellant by the Sarpanch asking him to tender his resignation. Paragraph. The contention of the appellant before the single judge was that the calculation of marks secured by opposite party number 6 in the qualifying exam was erroneous. It was contended that the percentage of marks scored by opposite party number 6 worked out to 37.54%, whereas the appellant had scored 38%, in as much as it obtained 342 marks out of 900. Paragraph. As noted by the learned single judge, initially opposite party number 6 had submitted in her application form that she had scored 413 marks out of 1100, inclusive of the marks secured by her in the optional subject. Full stop. The percentage then worked out to 37.54%. Full stop. Subsequently, it was realized that if the optional subject were excluded, then she would score 374 marks out of 900, the percentage which worked out to 41.56% in the CHSE. Paragraph. As noted by the learned single judge, the selection procedure involved giving weightage of 30% for matriculation, 30% for +2, and 40% for +3. Full stop. If such, as further noted, by giving such weightage, opposite party number 6 secured 46.20%, whereas the appellant scored 45.99%. Paragraph. It was plain, therefore, in merits that by virtue of the above calculations, opposite party number 6 was more meritorious than the appellant. Paragraph. Counsel for the appellant sought to contend that the select committee tampered with the calculation of the marks to unfairly favor opposite party number 6. Full stop. As noted by the learned single judge, the selection committee recognized that an error had been committed in calculating the marks secured by opposite party number 6 after excluding the marks for the optional subject. Full stop. That is how the marks worked out to 374 out of 900. And the percentage worked out to 46.20%. The admitted position is, as far as the appellant is concerned, his percentage worked out to 41.56%. Even after giving weightage, the appellant scored less than opposite party number 6. Full stop. Consequently, this court does not find any error having been committed with the learned single judge as far as the relative positions of the opposite party number 6 and the appellant on merit. Paragraph 2 then contended that there was a violation of the principles of natural justice, inasmuch as the appellant was not issued a notice about the discrepancy in the calculation and not given an opportunity to explain his position. Paragraph as rightly noted by the learned single judge, the marks scored and the calculations are all part of the record. And it would have made no difference even if the petitioner had been given a prior hearing to the end result. Full stop. The learned single judge rightly invoked the concept of useless formality. Full stop. In other words, even if the appellant were to be given now an opportunity for being heard, the end result would be no different. Paragraph. The court is unable to find any error having been committed by the learned single judge in rejecting the petition of the appellant.
Pardon, Your Lordship. In the meantime, the opposite party number 6, after the judgment of the London single judge, the opposite party number 6 had joined, and after 3 months, she was also removed from service. Now the post is lying vacant, Your Lordship.
So you are telling this after 25 minutes of argument, after 15 minutes of dictation. This is how you project your case.
Pardon, Your Lordship. In the middle,
no
I am seeking permission.
All right.
Item 77.
Yes.
That post is lying vacant, Your Lordship. I am struggling for that post.
What you should have said right in the beginning, you say after half an hour. This is the problem. All right.
Item 77.
Pardon, Your Lordship. Kindly consider post is lying vacant.
You can approach them. So we are not going to say anything on that. Yes.
Please, Your Lordship. But here this arises out of the Odisha Consolidation of Holdings and Prevention of Fragmentation of Lands Act. In other words, before I take your lordships to the impugned order of the learned single judge, your lordship will kindly take up section 34 of the Odisha Consolidation of Holdings and Prevention of Fragmentation of Lands Act. But there is a clear bar on the transfer of fragmentation of the chakra. That's the scheme of the act, your lordship knows, is to create a holding by consolidating all the plots of belonging to a particular person. So there is a bar to, I have a copy of the act, section 34. So I have got photocopies if you lordship.
We got it. Ask him to give it back.
Section 34, if your lordship kindly sees. Your lordship got it?
Yes.
Yes. 34 is prevention of fragmentation.
Yes.
Subsection 1 says no agricultural land in a locality shall be transferred or partitioned so as to create a fragment. Subsection 2 is no fragment shall be transferred except to a landowner of a contiguous chakra, provided that a fragment may be mortgaged or transferred in favor of the state government, a cooperative society, a scheduled bank. Well, this is a proviso. Your Lordship will then see subsection 3. When a person intending to transfer a fragment is unable to do so owing to restrictions imposed under subsection 2, he may apply in the prescribed manner to the Tahsildar of the locality for this purpose, whereupon the Tahsildar shall, as far as practicable, within 45 days from the receipt of the application, determine the market value of the fragment and sell it through an auction among the landowners of contiguous chakras at a value of not less than market value so determined. So therefore, the permission is required so as to transfer a fragment of the chakra, as per the section 34. Now, if your Lordship kindly sees the impugn order, that's for there being no permission, the present appellant filed an application under section 35, which is the appropriate remedy available under the Act. That application came to be allowed, and the transfer of the land in favor of the respondents was held to be void because no permission was admittedly taken. Now, your Lordship will see the impugn order. The discussion starts at page number 19, running page 19 of the appeal memorandum.
Yes.
Paragraph 7, if your Lordship kindly sees. Heard learned counsel for the parties, peruse the materials on record. There is no dispute to the fact that the initial transaction between Damodar Panigrahi and Satyavrata Raul, OP number 5, is without any prior permission under section 4.2 of the Act. But this should have been 34.2 of the Act. It is also not disputed that the case land is less than 1 acre. It is also admitted by the parties that said Satyavrata Raul, OP number 5, was not a contiguous chakra owner, but Satyavrata, subsequent to his purchase, sold the case land to the petitioner via RSD dated 24/12/98, who is a contiguous chakra owner of chakra 96, which is contiguous to chakra number 97. It is also admitted by opposite party numbers 2 to 4 in paragraph 11 of the counter, which is reproduced hereunder for ready reference. That it is humbly submitted that the disputed chakra number 97 is bounded by the chakra number 94, 96, 98, and 99. The owners of chakra 98 and so on. So just to show that the first purchaser was not a contiguous chakra owner. That is also admitted. In the course of hearing, Mr. Nayak, learned counsel for the petitioner, draws attention of this court to paragraph 30 of the case law in Sutar Chemical Supra, which is quoted below. But the question does arise when successive transactions have been taken place and the transferee has made some improvement of the property. The submission of Mr. Bob, learned counsel for the appellants, is that status of the land has been changed to homestead land from agriculture by the Tahsildar. Further, appellant number 1 has developed the land, constructed a way bridge in a portion thereof in 2008, and in another portion constructed a house, and has also installed an electric transformer for his business purpose. The same is neither disputed nor denied. In view of the long lapse of time of 17 years, successive transactions have been made, and the appellant number 1 has constructed a house, way bridge, and installed an electric transformer over the same. It would be too iniquitous to dispossess him from the said land in question. But this is the paragraph which is extracted from Sutar Chemicals, which was specific to the facts of the case, of that particular case, my lords. Now, my lords, the Lordship sees the finding of the learned single judge based upon the paragraph 30 of the Sutar Chemicals. The next page, page 21, if your Lordship kindly sees paragraph 8.
Yes.
Taking into consideration the submissions made by learned counsel for the parties and subsequent developments in the meantime, it is crystal clear that the petitioner, who is the subsequent purchaser, is a contiguous chakra owner of chakra 97 and has amalgamated his chakra 96 with case land. Thus, section 2M of the Act will not be strictly applicable to the incident case in the chain circumstances, as the case land no more remains to be a fragment of chakra 97, as it has already amalgamated in chakra number 96. And in that view of the matter, he allows the writ petition, Lord. But my humble submission is, admittedly, the first transaction was without permission. So that sale deed is a void sale deed under the Act. The subsequent sale deed, whether or not it is the person belongs to a contiguous chakra owner or not, but in my humble submission, it doesn't matter too much in the case, because the initial transaction is a void transaction. And the reference to the paragraph 30 of the Sutar Chemicals would not apply to the present case, because in Sutar Chemicals, it was a standalone matter where a lot of development had taken place, my lord. It had become an industrial locality where the way bridges were functioning. It was beside the national highway. So all those things were totally different from the facts of the case. Here, the land continues to be an agricultural land. And the only development is the change in the ROR. Well, that's the only change circumstance, my lord. So therefore, my lord, drawing a distinction from the facts and circumstances in the law laid down in Sutar
This
Chemicals.
agricultural land is in whose possession?
My lord, that possession part is also in dispute, because both parties are scrambling for possession at this point in time. There's a criminal proceeding also pending.
They're related.
They're not related, my lords. Because what has happened is the subsequent purchaser, as in after the first purchase, the land has gone to the second purchaser. That second purchaser is a contiguous Chakka owner. So he's creating the disturbance. He's of 96, I am of 97. But the first transaction, my lords, is bereft of any permission, and it's in clear violation of Section 34 of the Act.
My humble submission before your lordships, my lord. My lord, here, my lord, the rent is paying by the respondent, my lord. The rent is also paying by the present respondent one, my lord. My humble submission before your lordships, the father of the appellant sold the land to the respondent number 2, my lord, in the year 1995, my lord. Thereafter, the said respondent number 2 sold the land to the present respondent number 1, 98, my lord. The father of the appellant not claimed any regarding the sale deed is void or not. The father is not claimed, my lord. Now the son is claiming that the said sale deed is a void, and they filed a miscase under Section 35 of OCS PFL Act in the year 2009, my lord. I purchased this suit land in the year 1998. Nobody is claiming. But now the appellant filed a miscase in the year 2009 that the sale deed is a void. The sale deed executed by their father is a void deed, my lord. And now, after purchasing the suit land, my lord.
Declaring a registered sale deed to be void, you have to go for a civil suit, right?
Plus, if your lordship kindly peruses Section 35.
There's a
mechanism under the Act.
No, my lord, the collector has the authority. Collector has the authority to declare if it is violates that. Section 35 is clear.
Yes,
not
35
that
if your lordship.
in such circumstances the party can take resort to civil court. In such circumstances, there is not. 35 is there. But here in the case, what has happened due to the subsequent development, he purchased the contiguous. So the Honorable Single Judge held he has already purchased it. So there is no fragmentation of Chakka. His father has sold this land in as early as 97. After his death, perhaps son has filed this case under Section 35. So this is how the Honorable Single Judge has held that since there is currently there is no question of any fragmentation after this development.
Correct.
So
correct. Let things be as they are.
Yes. Because he has purchased it by means of a
registered sale deed.
Well, that's 95, the period of limitation as such. In other words, this delay in filing the 2009 application, Lord. But that the Sutar Chemicals also held that there is no limitation with respect to filing.
No, there is no limitation. Yes, you are correct.
That
limitation part is
the thing is ground reality has changed.
Ground reality has changed. I accede to the extent that only the ROR has changed. And there is an amalgamation of the Chakka on paper.
The occupation of that
occupation and paying the rent.
Paying
the rent, my lord.
There is no finding.
And also paying the rent for the year 2022 and 23.
So he's in possession also.
But possession, that finding is not there.
No. Finding meaning unless you say to the contrary. It's for you to. If you say he's not in possession, you have to show it.
No, but that's how I filed an FIR also.
That under registered sale deed, it's highly unlikely he's not in possession.
Because the fact remains it's a void sale deed. So that's your lordship.
From his point of view, sir. From your point of view, it's a void sale deed. From his point of view, he's validly purchased it, he's in possession.
No, but the 34 is a clear that the Honorable Single Judge has held that this sale deed is actually without any permission.
No, but again, which is the proceeding in which that can be declared?
Yes, yes. If your lordship kindly sees 35 for a second. If your lordship kindly peruses section 35. The statute is very clear, my lord. So section 35 is very clear.
No, eviction is one thing, sir. See, that's
No, but if your lordship kindly sees consequences of transfer or partition contrary to provisions of section 34, subsection 1 says, a transfer or partition in contravention of the provisions of section 34 shall be void. A person occupying or in possession of any land by virtue of a transfer or partition which is void under the provision.
Right? So there has to be a declaration that it is void. My question is, who will make that declaration? Once it is declared, this provision will invoke saying, since it is void, now evict the person.
But it's a summary eviction, lords. If your lordship,
eviction may be summary because the collector does not have to go behind a decree of a court. See, if you go to the civil court, you get a declaration that the sale deed is void. You come to the collector, you invoke 35(2) and say, now this declaration of void is there, evict the man. So he will summarily evict.
Plus, what my humble submission is, plus I have no, Lord, I can go to the civil court.
Yeah, that's the best.
But the only thing is that the
entire this provision, this is as a result of that declaration. Yeah.
But if your lordship observes that, I'll be obliged. If your lordship observes that,
all right. All right.
My lord, my respectful submission.
Yes.
Your lordship may not observe anything regarding jurisdiction or the power and authority of the collector to exercise section 35 because
the collector's power to evict, nobody is questioning.
No, eviction is followed by declaration of that it is a void.
Correct. That declaration the collector cannot give, sir.
Competent court has to declare.
But because here the entire scheme of the act would be defeated if the collector would not have the power to declare a sale deed as void. Because if he sees, my lord, my humble submission is, if he sees that a sale deed is executed,
authority registering a sale deed is not the collector. It's some sub-register.
Yes.
So how can the collector? He's not going to hold a trial.
No, section 35 is very limited scope.
That's
Collector
what,
is
only
to
for
examine
eviction.
whether there is contravention of section 34.
Yes, my lord, that's it.
So if that is contravention of section 34, so automatically by operation of law, the sale deed is
correct.
But here, in fact, there's no permission.
Some court has to declare it. Some court has to find that there is a violation of this law, that the transfer has taken place in violation of this law. Then based on that declaration, the collector will proceed to evict.
What I respectfully submit that here, collector is a quasi-judicial authority.
For the purpose of determining whether this, this person's plea under 35(2) for eviction is made out or not.
Plus, section 35(1), if I can read it again, my lords.
Yes.
The only...
See, 35(1) had said...
Yes, my lord.
On an application by a person,
yes, my lord,
the collector can inquire and find out if a transfer has taken place in violation of the law.
Yes,
and issue a declaration. There's no problem at all.
My lord.
34(5)(1) simply says a transfer in contravention of the provision of this law or section 34 is void.
Shall be void, my lords.
It doesn't give you the procedure for arriving at that result.
Section 35 itself is a procedure to be adopted by the aggrieved party.
Only for eviction, sir. Only 35(2) you say.
Harmoniously, you have to read both.
The person occupying or in possession of land by virtue of a transfer which is void. That is 34(1).
But in normal case, what I beg to, according to our practice here, the collector, one application is to be filed before the collector. Collector will determine that whether this sale deed is in violation of section 34. If that is there, then
there is no such.
May I just
it's a registered sale deed, sir.
May I just take certain amount of days to examine that the collector can do so, my lords. Only on that.
Lordship can give some time.
Yes,
he will please, because this otherwise the law will be let down.
Yeah, want to examine the scope of the powers of the collector under section 35 of the OCH and PFL Act 1972 at the request list on. September.
My lord, give a short date. I will also come with preparation and.
It's all right.
This is an interim order, your lordship will.
Interim order.
Okay.
All right.
Item 78. May I please, your lordship?
Yes.
In this case, notice was issued earlier, my lord. And as per noting, no delivery report has been come back, but I don't know what's mentioned this.
All right. Fresh notice to
The notice already issued, my lord. This is notice.
undelivered, sir. If you read the cost slightly, you'll find it's undelivered.
Yes, my lord. Fresh notice.
Fresh notice to respondents 2 to 10. By registered speed post, the tracking report will be placed in record. On the next day, 13th September.
Item 79. Obliged.
79.
May I please, my lords? The judgment dated 3/11.
Undelivered. Respond by 18. Come back undelivered. Saying wrong address. Notice to respond by 18 is returned undelivered with the remarks single quotes wrong address. The appellant will ascertain the correct present address of respond by 18 and furnish it to the registry within 4 weeks. Thereafter, fresh notice at the changed address. Returnable on the next day. Tracking report will be placed in report. Again, 13th September.
Item number 80.
My please, my lords. So in this case, though originally there's 4 questions are framed, lords. The last occasion, lords, I have given a memo, my lords, whereby the questions are boiled down to 2, and essentially there is only one question survives, my lord, for lordship's consideration. That is, my lords.
68. Additional to 68 in respect of share application money.
My lords, my lords.
Right.
That is given on 30/10/2022, my lords.
Right.
The only question is whether the income tax appellate tribunal was correct in law in sustaining addition made by the assessing officer under section 68 of the Income Tax Act in respect of share application money relating to on-track trading limited, a foreign company, which admittedly has contributed share capital, having no dispute as to identity and source of such investment. Even an assumption that SEC has failed to discharge the financial capacity of the state. This question, in fact, resembles with one judgment. Very same question was framed in People's Madhya Pradesh High Court judgment. Anyway, that's what I am impressing with lordship, lords. In this case, I will take my lordship's attention, lords, to the order passed by the CIT appeal, lords. Because in the first instance, before the assessing officer, lords, the question is, lords, that was the introduction of fresh capital by way of share application money of 34 crores, lords. Because out of the 5 lords, investors, lords, those who have given, one of the investors was lords, foreign investors. And he has purchased lords 4,31,000 some odd shares at the rate of rupees 10 lords. And in respect of that investment, lords, all documents, your lordship may kindly see what are the documents filed before the CIT appeals, lords. For that, your lordship will kindly see Annexure 8 at page 111 and relevant page is 112. 112 minutes. The appellant during appeal hearing submitted additional grounds of appeal as well as application for acceptance of additional document evidence by CIT appeal. The appellant during appeal hearing submitted following documents. In addition to the documents earlier furnished during assessment proceeding, the same constitute details of on-track trading, such as 1. Certificate of incorporation, bank statement of basis on-track trading limited, PNB, it's Punjab National Bank, certificate of remittance of foreign currency by on-track trading limited, D. Millers, form of FCGPR and assess the intimation to RBI. FCGPR is a statutory information which I have to make a declaration, Millers, to the RBI, Millers. CS certificate, letter dated 17/3/2010 of RBI for acceptance. All these documents, Millers, goes to show that money has come through banking channel. Information was given to the Reserve Bank of India. The Reserve Bank has accepted the FCGPR, Millers, the declaration given, Millers. So, Lordship, may kindly see one document I am showing to Lordship. That is, Millers, at page 47.
So 2 reasons which are given, page 132.
Sorry, Millers?
132.
132, my lords. Page 2.
In fact, you can start at para 7, page 131.
Yes, my lords. Para 7, yes. But after hearing both sides and perusing the entire material available record, along with the orders of authority below, we find that during course of assessment proceeding, the assessee could not furnish any details except for number 2, which provided details of allotment, but no details regarding from where and how investment came. The AO found that the creditworthiness of the investing company is not proved by the assessee. Therefore, he treated the sum credited in the books of accounts of the assessee as unexplained and charged the same under section 68 of the Act. The CIT appeal from the verification of all the documents placed by the assessee during the appeal proceeding found that the amount had come in foreign currency through banking channels to the assessee company. Since the investing foreign company has been registered, etc., it appears that it has an identity. So identity established, foreign banking channel is also established. Then, but the most important evidence missing in the whole transaction is the proof of creditworthiness of the investing company. Further, the CIT appeal observed that the assessee did not produce reasons for investment by the foreign company with the assessee. Even the assessee has not filed any confirmation from the foreign investing company or the directors regarding such investment in shares, and the assessee company in absence of above evidence.
So what do you have to say for this? So the question is, we know the identity, but we don't know the creditworthiness.
My lords. Now the question is,
what is the reason? Why should that foreign investment company choose you to invest?
Exactly, my lords. The reason they say that you have not given reason. Reason your lordship will find from the very statutory document. That my lords may kindly see.
No. For creditworthiness, did you produce the balance sheets of that company which invested?
What I have filed, plus one after other, let me show to your lordship, so that my lords will see. Your lordship may kindly see. Let me start with your lords, the documents which are there. At page, my lords, the entire document, page is, it starts at page 55. For a moment, my lords may kindly see. 55. 55 is the certificate of incorporation of this on-track trading limited. Then, my lords, 56. This is the United Bank of Singapore bank statement, my lords, where your lordship will find on this date, my lords will kindly page 56. Outgoing payment, Gopalpur Ports Limited, $5 lakh twice. Total is $10 lakh he has given towards share application money. The amount is, amount is debited from the company's account at page 56, and other entry your lordship will find at page 58, my lords. Then your lordship may kindly see, page 60, information by the petitioner to the Deputy Manager, Foreign Exchange Department, Reserve Bank of India. My lords may kindly see. All details are mentioned here. This is to inform that we have received the following remittances from abroad on account of investment in equity shares. Then the banker certificate, page 61, Punjab National Bank. My lords may kindly, page 61.
Yes.
My lords, equity share, 5 lakhs, your lordship will find 40 at the rate of 42.33 rupees per share, and $50,000 US. Currency amount $50,000. This is one, and another also equal amount, same amount, $50,000, another rate 26/8/2008, page 62. These two remittances are there, my lords, total. Then my lords may kindly see annexure 1. Page next is page 29 is a forwarding letter, page 63. Page 64, you, my lords, may kindly turn to page 64. This is part A of the FCGPR, which is a statutory intimation I have to give, lords. A permanent account number of the investing company given by IT department, date of issue of shares, convertible. Then you will may kindly see the reason. The assessing officer says that you have not given reason. Column 2, the last minutes of the table, rehabilitating the existing minor port and developing a direct berthing deep water port at Arjipalli, Gopalpur, District, Ganjam, Odisha.
No. This is your explanation, sir.
My lords,
this is your explanation that you are offering.
Yes.
The question is, why did that foreign investor want to invest, and what is the creditworthiness of that foreign investor?
Exactly, my lords. Your lordship, there are so many judgments are there. So far as section 68 is concerned, my primary onus is on me, my lords.
Correct.
I have to satisfy that the person who has invested money, I have to disclose identity. I have also to explain that how the money has come, and where it has come. Now, the question is, so far as Daulat Ram's case is concerned, the Supreme Court said, source of source is not the obligation of the company. But so origin of origin, source of source. I have settled to establish, the money from where it has come, whether it has come through banking channel, or recorded payment is there.
No, that is the identity, sir.
My lord's query is creditworthiness of the investor.
Absolutely, my lords. The money was there in the company in the name of the investor, my lords.
No, how does it automatically establish the creditworthiness of that company, please?
Yes, that your lordship have said in so many judgments, because creditworthiness means to the section 68 only requires me, my lord. Your lordship have decided. My lords, I have judgment of your lordship also, my lord. And I will take your lordship's attend so many judgments where the section 68 says there is an amendment now, my lords, from 1/4/2013. Beyond 1/4/13, my lord, the obligation now extends to establishing source of source. That is a deeming provision. Until 2013, my lords, my primary onus is to establish that, my lords, I have to identify first who is the investor, my lords, and whether the share application money has come from through right channel, my lords, banking channel, or it is in cash, my lords.
No. In those cases also, there are so many shell companies formed, sir. So you can show that the company is registered, that the company is issued the check, so you know the identity of the person issuing it. But if the company itself is a shell company, then what is the creditworthiness of that company? That is why creditworthiness becomes important.
If your lordship want me to, I will show you.
See, the other cases, including those which you are referring to, the judgments, they were able to show that those companies had filed returns, which were accepted. There's no such evidence here. If this happens to be a foreign company, then you are in greater onus. You have a greater difficulty. Those were Indian companies, they subscribe for share application. Then they were able to show that we have filed returns. Our AOs have accepted it.
So if you want me to, I will.
Not at this stage. See, normally at the CIT appeals, you file an application asking for additional evidence to be taken on record, on which a remand report is called for from the AO.
That's all.
All that stage is crossed already.
That's all. May I take your lordship's attention, my lords? I have given a compilation. My lords may kindly see. Because the way, my lords, this has been dealt in, if I may take your lordship's attention, tribunals order, my lords. Thereafter judgment, if your lordship.
All right.
Annexure 11, it starts from page 134, my lords.
Correct. And we were reading 132. 132 is what we were reading, sir.
No, that's the findings, my lords.
No, that's what. Findings started at 131 and the actual finding was 132.
And finally, your lordship will find from...
No, so they've narrowed it down to two things. One is what is the creditworthiness of that foreign company.
Correct.
And actually the second is linked to that. Why would that foreign company choose you to invest?
Yes, now what is creditworthiness? Well, how the courts have dealt with this creditworthiness. That I want to, my lords. I will first, my lords may kindly see the compilation. The compilation there. The first decision, I rely upon is Commissioner of Income Tax versus People General Hospital Limited. This is a case, Mirrors, where money has come from Mirrors outside the country. Unlike other cases, Mirrors. My lords may kindly see the question. The question is very much identical to the question which your lordship have in this case. I am reading the question, Mirrors. My lords may kindly see from the compilation at page 4, the question. What is the question framed?
Not scanned.
Check it. The result
Yes.
So, page 4, question is whether the income tax appellate tribunal was correct in law in deleting the addition made by the assessing officer in respect of the non-resident Indian company, which admittedly has contributed share capital, even on the assumption that the assessee has failed to discharge the financial capacity of the non-resident Indian company. This is the question, Mirrors. Then going by fact, precisely, paragraph 7, in this case, the return was filed on 13/10/2003 in which income was declared as nil. The assessment order was passed on 1st March 2006, by which the assessing officer made an addition of 21 crores 27 lakhs so and so, and assessed the income of the respondent at 21 crores same amount. The aforesaid addition was made on the ground that Messrs. Alliance Industries Limited, Sharjah, that is a United UAE, had made share subscription to the capital of the respondent. The assessing officer doubted the creditworthiness of Messrs. Alliance Industries Limited, Sharjah, and directed addition of the amount of share subscription provided by the aforesaid company to the assessee. In all the 3 years, the amount of subscription was directed to made addition to the income of the respondent. This is your situation. This is the fact, my lords. Completely same as that of the present petitioner. Now, your lordship may kindly turn to the findings, my lords. That is paragraph 17 and 18. Two paragraphs only I will place, my lords. Paragraph 17, it has referred to, my lords, so lovely exports, apex court judgment. Then can the amount of share money regarded as undisclosed income under section 68 of the IT Act? We find no merit in this scheme, especially petition, for the simple reason that if the share application money is received by the assessing company from alleged bogus shareholders whose names are given in the assessing officer, then the department is free to proceed to reopen their individual assessments in accordance with law. Hence, we find no informative with the next paragraph. The aforesaid judgment has been followed by all the courts.
There is a huge difference, sir. Up to page 72, the printed page 72, internal page 8.
My lords.
I find that the assessing officer himself accepted similar deposits in earlier assessment years as genuine.
Let's say your lordship is 72.
6, 7, yeah.
The assessing officer was not justified in drawing mirrors.
No, after saying the assessing officer has himself accepted the identity of the share applicant money.
Yes, the assessor himself has accepted identity of the share applicant company and also the genuineness of the transactions in respect of this deposit. I find the assessing officer himself had accepted the similar deposit earlier assessment years as genuine. Right. In fact, the assessment order relating to assessment year was passed after inquiry under 1.3, wherein similar investment from the same non-resident Indian company to the tune of rupees so-and-so was accepted as genuine, and investment of so-and-so from the same company was also accepted under section 143(1) for the assessment year so-and-so. There is no deviation. So they have accepted this.
No. Because there was a pattern, sir. This whole determination of creditworthiness happens because so many years the same company has been investing in this SSC company.
Yes, sir.
So 1 year, all those years you accept, suddenly this year, why would you reject? So he says, I can't suddenly reject saying not genuine.
That is pattern, but I want to bring to lordship's notice how creditworthiness is addressed, my lord. That my lordship kindly see. The aforesaid judgment is followed by all courts, and the judgment relied on by the appellant relates to period prior to the judgment in lovely exports. As the apex court has specifically held, if the identity of the person providing the share application money is established, then the burden was not on the assessee to prove the creditworthiness of the said person. However, the department can proceed against the said company in accordance with law. The position of the present case is identical. It is not the case of any of the parties that Alliance Industries Sharjah is a bogus company or a non-existent company, and the amount which was subscribed by the said company by way of share subscription was in fact the money of the respondent.
Whereas here you can't say that. There, in the facts of that case, there was no doubt.
My lord, here, my lords, your lordship will find tribunal also recorded finding that the identity is established. The money has come through banking channel, and my lords, the money which I have, my lords, this appellant company received, my lords.
Sir, you could have produced the balance sheet of that investing company.
Yes, I will find out, my lord. If your lordship permit, because I have given rejoinder. No, not rejoinder notice. They say rejoinder, they have not received notice. I will.
One of the issues that has arisen as far as the present case is concerned is the issue of creditworthiness of the investor, foreign investor, in the SSC company. In other words, although the identity of the company investing was established,
and so also mirrors payment through banking channel also there is no doubt on it.
And that payment was received through proper banking channels. The question of creditworthiness still remain to be answered. Paragraph. Learned senior counsel for the appellate requires time to study this aspect of the matter further and address further arguments. Not to be treated as partial. List on 10th August. Yes.
Where's the interim order to continue?
Is there an interim order? This is ITA matters. I don't know. Is there an interim order?
Probably yes.
It's made absolute.
Absolutely yes.
Already made absolute.
Minor.
Then it's
Pastor matter item number 13.
May it please your lordship, my lord, I am in BCMA.
Yes.
My lord, here my registration has been cancelled, my lord.
Yes.
Without giving me any opportunity of hearing, I have given the similar order that has been passed, my lord, in Santoshi medicine case. That for condonation of delay in revocation application on section, my lord, 30 and rule 23.
All right. Same order. All right.
Pastor matter item 27.
In this application, may I plead your lordship, my lord? In this application, the petitioner seeks direction to the concerned Tahsildar and the sub-collector. They are implicated as OP number 3 and 2 respectively to implement or to execute their own eviction orders. The eviction orders are in favor of the petitioner, but these orders are not being carried out only for the reason of a political interference and by so of activism. The OP number 4 is not vacating, though he has been clearly directed by the orders of the under Annexure 1 and 5. Under Annexure 1, the learned Tahsildar has passed the eviction order, and that has been in an encroachment proceeding. That order has been passed by the learned Tahsildar. And that has been also confirmed, and the OP4 went in appeal before the sub-collector, and the sub-collector confirmed it. And thereafter also the eviction order is not being carried out. It cannot be possible for execution for the reason of political interference. And the OP4 is also showing activism, and
it is not known as to whether they have preferred any revision against that order or not, because there is no such pleading in the petition that no revision is preferred against that order before the revisional court.
Correct. Have you preferred a revision, sir, against sub-collectors?
No. The eviction orders under Annexure 1 and 5 milers are in my favor.
Correct. But 26 and 22 is against you.
I will ascertain, your lordship may keep it to next week. I will ascertain whether revision has been filed or not.
All right. Consequently, petitioner requires time to ascertain if any revision petition has been filed against the impugned order of the sub-collector. At his request, list on.
OP4 is to file revision, not because...
No, OP4 is to file it.
Yes, OP4 is to file the revision because the impugned order, the orders are in my favor. But these are not being carried out. That is the sole question.
12 July.
Item number 46.
Connected ancillary issue is pending before the Supreme Court. I'm just giving the order. So it is in SLP civil number 4468 of 2022. So if that Supreme Court allows, then we will also pay. I've given last page of that, page 13.
Right. It is stated that a similar issue.
Ancillary point, not directly, but
SLP Civil 4468 of 2022 is pending in the Supreme Court of India. List on. September.
Both matters same order.
Correct.
Hello, weekly list.
Weekly list.
Going to the weekly list, item 47 and 63. Both are covered material lordship's order. Annexure 3,
item
47 and 63.
47 and
24 years, cancellation of lease by ADM, my lord.
You are the subsequent purchaser.
Yes. Annexure 3.
Your Lordship, let me verify this to record.
Let it
Your
come
Lordship,
tomorrow, I will serve a copy.
No, I will verify this records, please.
Tomorrow.
Oh, yes, tomorrow.
Another item 100, my lord. That is the covered by the Narottam case, my lord. Ace order, but Annexure 7 and 8.
No, it's ASO's order.
SO order and both are SO order. They have created two case, show motor case against one plot mine. Both are same order under Annexure 7 and 8. Out of 500 dispute,
No. Question is what you challenge is an appellate authority's order or ASO's order?
Appellate authority order.
The same as this.
Both are appellate
The
authority.
judgment score. State it, whatever, in Narottam Ratna. The following direction section.
7 and 8.
All right.
100. About item 100.
100.
Weekly list item number 1.
Whereas item number 18, whereas I had twice prayed for the state's counter not being solved on.
It will get called out, sir. We'll just call it out.
Item number 1.
May I please? My lord, here in this case, the land of the family, that is the land of the grandfather of the present petitioner, was acquired by the opposite party pursuant to a notification issued in the year 1982. I have given a debt chart, my lord. Lordship may kindly go through the debt chart. The notification issued in the year 1982 and in 1986, the compensation amount was paid. But with regard to the employment, the owner of the land, my lord, executed a affidavit under Annexure 2, nominating his grandson to get the rehabilitation benefit from the opposite party, number 1. And also, he has given a undertaking before the learned collector under Annexure 3, that is on 10/9/1990. And the owner died on 27/11/2002, my lord. I have annexed the legal heir certificate under Annexure 6. Thereafter, the present petitioner, when approached the opposite party, they have stated that since you are not coming under the definition of the family, we are unable to give you the rehabilitation assistance scheme. That is their stand.
Yes.
And they have filed the counter.
No. They've said Pramila Mudali. You are claiming that your mother is Pramila Mudali.
Yes.
Right? And she is supposed to be the daughter of Chandra Behra.
Yes.
Where is the proof of that?
My lord, that is legal heir certificate. Lordship may kindly see Annexure 6, page 16.
No, it says it contradicts the record. That's why.
Page 16, Lordship may kindly peruse. The legal heir certificate issued by the competent authority.
Actually, this is not some declaration by a court of law.
This is the legal heir certificate issued after the death of Chandra Behra.
See, anybody can, let's just go there to an office and somehow manage to get a certificate. Is that proof of the actual relationship?
That is,
you are disputing. We say that he should get that claim through a succession certificate and not a legal heir certificate.
Correct.
Because he fails on both grounds. First, he says that he'll get his father's, the compensation in lieu of his father's land. But
In his mother's land.
But looks like that he's the second son. So the first son has got it. Then he claims through his grandfather, maternal grandfather. The maternal grandfather has filed 2 affidavits come into play. One affidavit in 1990 says that he's 62 years old. He appoints this petitioner. Another affidavit filed in 1998 says that again the Chandra Behra is 62 years, same after 8 years also, and he appoints someone else. So those are contradictory. So therefore, my lords, we find that there is another daughter of Chandra Behra.
No.
He has a son.
There is no daughter of
He has been
Chandra
nominated. That is what my lords will find at page 12.
What they are saying, my lord, I have got it through RTI. Lordship may kindly peruse.
Page 12 of my affidavit.
Lordship may kindly peruse. What they are disputing that they are saying that one Obola Muduli is the daughter of Chandra Behra. My lord, under RTI Act, I have obtained the document, the status of Obola. Obola is not the daughter of Chandra, my lord. Obola is the daughter of Rathia.
Yes.
That second page of that document, Lordship may kindly see. That is obtained through RTI. Obola is the daughter of Rathia. That is
So a copy of the document.
We have that document, let them file, but on behalf of MCL, we will file the counter. In that particular counter, we have taken the specific stand what my learned friend has submitted to the court. And we have also given the genealogy, Lordship, page 3. And
that genealogy from that RTI document.
Apart from this, out of 2, one person has been taken to consideration. According to the scheme, one person has been enlisted and given service. So, whatever land they have sacrificed, apparently all these things, one per scheme is completely accepted by the authority and one person is given privilege appointment. So the question of taking consideration of the petition could not be a right matter. And we have taken specific stand what my land friend says.
No, what you file this with an affidavit because they have had no chance of seeing this.
My lord, yes, my lord.
You say this.
I will file it through an affidavit. Yes.
Counsel for the petitioner in the course of his arguments sought to rely on certain fresh information obtained by him under the Right to Information Act from the office of the Tahsildar.
Yes, my lord. PIO cum Tahsildar.
The said information be placed on record by way of an affidavit.
Lordship.
Within 2 weeks with advance copy to counsel for the opposite parties.
Lordship.
5th September.
My lord, 5th September.
Obliged.
Item number 2.
Obliged.
This is a case regarding payment of margin money to a loanee, small scale industry, my lord. My lord, under the scheme floated by the government of India, the state government processed the same. My lord, the margin money could not be paid, my lord. But in the present case, the government of India has not filed counter. The state government, they have stated that since delay has been committed, the margin money could not be processed. But government of India has not filed any counter, my lord. 250,000 given as a margin money for the small scale industry, my lord. Government of India has not filed counter yet, my lord. So because the funds will come from that, they have the state government, they have stated that delay was committed. Financial bank has stated that we have recommended. DIC also stated they have recommended. But no counter is coming from the government of India, opposite party number 7, my lord. Without that, it is difficult. Whether that funds will come from them, my lord.
No, when is the margin money taken from you?
That is before the first phase of disbursement of loan. And that's para 10 of my counter affidavit. Para 10.
No, before the.
Let me read para 10 of my counter affidavit. It is respectfully submitted that as per guidelines of Rural Employment Generation Program, the beneficiary is to deposit his or her contribution at the rate of 10% of project cost before first phase disbursement of loan at bank. In the instance case, the petitioner has not deposited the required margin money at bank, that is called the promoter's contribution at the rate of 10% project cost, that is 1 lakh rupees, prior to the disbursement of loan to him at bank, which is determined from the bank statement of petitioner's account number so and so. Since the petitioner failed to deposit the required margin money before the first phase of disbursement of loan, and also did not submit the margin money subsidy claim paper to bank within the stipulated time, it was not possible on the part of the Secretary Khadi and Village Industries to release margin money subsidy in favor of the petitioner in due time.
Where that money was deposited in page 24 and along with the application, my lord, in 2007, my lord. In 2008.
No, you've not filed any rejoinder to this.
I have filed rejoinder, my lord.
When?
You don't have a copy.
The rejoinder file.
Rejoinder filed on 3/3/2014.
14? No.
Why?
No. There's no rejoinder served.
There is an affidavit. There's an affidavit of 24 June 2016.
My lord, just verifying, my lord.
That is rejoinder. That's not the. All right. Counsel, the petitioner seeks to file a rejoinder to the counter affidavit dated 24th June 2016 of opposite parties. Number 1. The affidavit we filed with the next date, including the rest of regular matter. (29th August).
Item number 3.
On item 3, in this case, I challenge the award dated 30th June 2011 by the Annexure 3. And the reference was for the termination of service of so and so with effect from 1/10/2005 by the new employer, management of Mrs. Indian Farmers Fertilizer Corp Limited by the erstwhile Oswal Chemicals and Fertilizers Limited is legal and justified at page 27. One of the opposite partner 2, since then is getting the benefit of 17B and we are complying the 17.
I'm appearing on behalf of the opposite party, number 2.
So 17B you're getting regularly? That's what he says.
Yes.
Okay.
Malasi, actually she was appointed by the erstwhile employer, Oswal Chemicals Limited, and but she remained absent unauthorizedly, for which her services were terminated, and she never worked under the present new management. And he filed his written note the written statement before the labor court, claiming that it amounts to a refusal of employment. There is no written notice pay and compensation were given as per the provisions of Industrial Dispute Act to the second party workman by the management of IFCO. And when we took over in 1/10/2005, she appeared and said that I am joining today. But she is entitled for the compensation in terms of section 25 FF minor, because the undertaking has already been closed and she never worked under the new management from 1/10/2005. This new undertaking has taken over, and the 25 FF says compensation to workmen in case of transfer of undertaking. In this case, the undertaking has been transferred to IFCO, and I do not know about the present petitioner does not know since when she was working, but she claims that from 1/10/2005 I appeared, and he claimed that she claimed that.
No, first of all, Mishra should know how old is she now.
I think 50, early 50s, I think.
Lord, she's 46.
Ah. So
And so far,
full reinstatement is ordered, right?
Malad,
Reinstatement is ordered.
in view of the agreement executed between Oswala and IFCO, we have already taken over 1,292 employees.
Lord, she was
by virtue of the agreement. And her name was not there.
Lord, she was engaged.
Now the industrial tribunal are directed for reinstatement with back wages. And since then we are complying. And today it is not possible to it is part of some compensation can be paid through 25FF. In that event, we are ready to pay. And the minor sent it for conciliation, but she did not agree. And she claimed 45 lakhs.
49 lakhs.
45 lakhs.
45 lakhs.
Excluding the 17B compliance.
Oh.
So it could not materialize. It was once sent to the conciliation center. So it could not be if a minor's intervention, it can be settled out of court. In that event, we can pay and 45 lakhs is the exorbitant amount she claims. So for that, it could not materialize. And we offered her that we are ready to pay 10 lakhs, excluding the compliance.
Sorry?
Excluding the 70B compliance, we offered 10 lakhs. But she did not agree. So for that reason, again, matter has been.
Yes, Mr. Mishra, you heard that?
Yes, my lord. May I just, because I was not conscious about the settlement which has taken place in the mediation center, because I have no instructions to that effect, but I'll just tell your lordship.
No. I think you better find out.
I'll find out, but just the facts of the case, I'll just tell because they even.
We might not. Why do you have a truncated hearing? Then again, we'll adjourn for you to find out after hearing the documents.
My lord, I'll just tell one sentence because this is just one sentence which your lordship should know, that she was engaged by the erstwhile management after the death of her husband. She's a widow. She was engaged after the death of her husband, maybe on compassionate grounds. I do not know. But what the tribunal has ordered is reinstatement with full back wages.
Correct.
So therefore, what would be the quantification? I have no idea. But if your lordship grant a week's time and take this matter on the 6th of March, maybe I'll come back to your lordships with the relevant.
All right. Stay on board. We call it on 6th.
Item number 4.
May I please, your lordship? My lord, the petitioner challenged the action of the opposite party in not revising the tariff from general purpose category to agro-industrial tariff as held by the ombudsman as per the amended provision of the OIRC code, my lord. My lord, the petitioner's unity is a cold storage and it's covered by your lordship's judgment, which is your lordship already held that cold storage are.
Milord, so far this filing of writ petition, Milord, there is no scope for the petitioner to come to this honorable court, Milord, because the ombudsman has passed an order, Milord, and Milord, if the consumer is aggrieved that the order of the ombudsman is not being complied with, Milord, remedy is available to approach the OIRC, Milord, under section 42 of the Electricity Act, Milord. Milord, so far this order of ombudsman is concerned, Milord, that is dated 9/3/2011, that is under challenge, Milord. Milord, this OP number 4 is a commercial consumer, Milord.
Have you seen this order, sir?
Yes, Milord, I have seen that, Milord.
Then Mayurban.
Milord, that is applicable to the cold storages, Milord. But so far the activities of the petitioner is concerned, Milord, that consumer is concerned, Milord, Milord, he is purely a commercial, Milord. Milord, cold storage, Milord, he purchases the storage items from the market and he does business, Milord. It is not agro-based consumer, Milord.
No, but I don't understand. So what? The short question is whether this his activity falls under the description of allied
Milord, if he carries on that activities of cold storage, Milord, then it is all right, Milord. Lordship may see the tariff clarification, Milord, under regulation 83, Milord.
Yes.
What has been clarified, Lordship have a glance to page, Milord.
in single judgment, my lord, 85-3. 85-3, my lord, Roman 3, my lord. I'm in BC, my lord. I'm sorry, my lord, I'm in BC. My associate is there. That is the order in single judge order, my lord. Honorable order in single judge, there is a specific, like 85.
My lord, Mr. Mahapatra, I am assisting. My lord.
Allied Agro Industries Act.
My lord, this notification, my lord, regulation 85-3, my lord. This, my lord, this category relates to supply of power to cold storages. That is a temperature controlled storage where flowers, fruits, vegetables, meat and fish can be kept fresh or frozen until it is needed, and includes the chilling plant for milk and only the cold storages attached to processing unit for meat, fish, feed, prawn, flowers, fruits, fish, vegetables, my lord. My lord, here, my lord, if at all, my lord, he carries on, complies the requirements of this cold storage, my lord, at best he may fall in this category, my lord, as your lordship held in that decision, my lord. Your lordship may observe that, my lord, if he complies the requirements of cold storage, my lord, then only he can be eligible provided he executes the agreement with the license, my lord. From the date of execution, my lord, as per this regulation, my lord, the benefit can be extended, my lord.
No, not prospectively, sir. That anyway he will get. But this is for an earlier period, correct?
No, my lord, agreement he has not come forward to execute the agreement, my lord. My lord, from the date of execution, earlier agreement was for commercial purpose, my lord, general purpose, my lord. And the moment he executes, enters into an agreement for supply of power for that particular purpose, my lord, then matter will be verified, my lord, and it will be extended, my lord, benefit, my lord, as per your lordship's order.
Here, the period we are considered is 1/4/2009 to 31/8/2009.
My lord, that is the observation of the ombudsman, my lord, that from the date when this regulation amendment brought into in the regulation, my lord, that is the observation the ombudsman has quoted, my lord. My lord, from the date he enters into an agreement, my submission is, my lord, from the date he enters into an agreement under that category, my lord, then, my lord, tariff extended will be extended from that date, my lord.
Yes, Mr. Mahapatra. You have to unmute yourself, sir.
And, my lord, in another cold storage case, my lord, matter is pending subject before your lordship, my lord, in narrative appeal. The Honorable Single Judge has said that the moment you execute the agreement under that particular category, the benefit will be extended.
Where is that appeal?
And that appeal, my lord, 107 of 2014 or 19, my lord, I will give.
What's the
107.
date fixed for that?
My lord, just now, just remember, my lord. 107 of, my lord, I will give the number.
Find out. What? Give the number. Give the number. You don't remember it?
Sir, the year exactly I have not remembered, but it is 107 of 2014 or Mr. Dayananda Mahapatra is appearing in that case, my lord.
Are you aware, Mr. Mahapatra? Maharana, sorry.
No, my lord, actually, this is after the my lord's order, that is the judgment of, I have served the copy, my lord, in WA number 491/2013. That is an identical matter.
No, that is
After the fourth amendment, my lord, 2007, they have changed that agro-industrial category, industry consumer, my lord. After that, they have again recategorized my lord under GP category. After the fifth amendment, that is the 85-3 amendment. They
give us the number, sir.
That is, my lord, 107 of 2000.
First, find out, show us an order copy. You get a copy and bring it to us. Don't put all the burden on us.
No, I'm sorry, ma'am. I'm sorry.
Stay on board.
My lord.
Item number 5.
Okay.
May I please, your lordships? But in the present case, your lordships, I had shown to your lordships a decision, my lord, which is published in the year in 2012 to CLR, page 8 to 6. In the case of Srimati L. Patnaik versus State of Odisha and others. Here, my lord, I had shown to your lordships the para 9 of that judgment.
That decision has been taken care of in the subsequent
I will
decision
come
as
to
a
that.
House.
Yes, Your Lordship. That subsequent decision I have
So you
gone
have
through
to,
that. But
address on
fact
this.
remains that I will show
practice.
decisions, and also I will take to Your Lordship to the fact of my case. So that my Lord, it will be Your Lordship, I may be permitted to read the para 9 of that judgment. That in case of Peli.
All permissions granted, sir.
Further, we find that the original lessee was granted long back in the year 1974, whereas the revisional authority initiated the suo motu revision in 1998, that is after a long lapse of 25 years. Under the second provision to section 7A3 of the Orissa Government Land Settlement Act, no proceeding can be initiated after the expiry of 14 years from the date of order granting lease. While prescribing the period of limitation, the legislature, while drafting the Orissa Government Land Settlement Act in their wisdom, prescribed the period of limitation for initiation of a proceeding in examining the correctness of the order passed under the Act, and also to find out if any fraud or misrepresentation etc. was practiced in obtaining an order. Being cognizant of such contingencies, the period of limitation of 14 years has been prescribed. The reasons assigned by the Additional District Magistrate Bhubaneswar about the fraudulent declaration made by Digambara Behera that he belongs to scheduled tribe community and fraud was practiced to get the land settled in his favor can be decided by the revisional authority as per terms of provision, but within the period of limitation. But my Lord, this finding that he belongs to scheduled, my Lord, in my case, I belong to scheduled tribe, admitted. And the petitioners are the purchasers from the legal heirs of the lessee. And Your Lordship, I will take to Your Lordship to para 4 of my writ application. Then I will take to Your Lordship the decision, my Lord, the subsequent passed by Your Lordships.
Para 4.
Para 4. That it will be found, my Lord, at page 5 of my brief.
Yes.
That it is relevant to mention here that while original settlee Govardhan Majhi was in peaceful possession of the leasehold land, after paying his rent from time to time, as ill luck would have it, he died in the year 1983, leaving behind his widow, opposite party number 4, and minor children. After expiry of more than 10 years from the date of settlement, when the widow of the original settlee opposite party number 4 was in peaceful possession of the said leasehold land, wanted to sell the said land due to requirement of funds. As the vendor was belonging to scheduled tribe category, in order to sell the land in favor of the petitioners, she also obtained permission by the order dated 2/2/1984 in revisional miscase number 484 of 1983 from the revenue officer Bhubaneswar, which is required under section 22IB and section 4 of the OLR Act 1960. She has also obtained permission and NOC from the Bhubaneswar Development Authority to sell the aforesaid land. Now their stand is I don't belong to scheduled tribe. Normally, a caste certificate is issued in my favor and a permission is obtained from the competent authority, and there is one existing order passed by the competent authority. They are now saying that you don't belong to scheduled tribe. And not that in the year 98, Your Lordship may kindly say, I will take to Your Lordships to Annexure 5. Annexure 5, the order of redemption was passed. Your Lordship may I will take to Your Lordship at page 65.
Yes.
That ground was not there. That was held by Your Lordships in subsequent order. That is in the year 98, it was detected. When the detection was made, that is not clarified in anywhere. But in 98, my Lord, it is said, though the land was leased out in which purpose, for that purpose it is not utilized. For
That is a very tame thing, sir.
No,
here the only question is does fraud vitiate everything?
No, it is not fraud vitiated. And moreover, my Lord, if Your Lordship will be found enough, here, my Lord, this finding is not taken care of in the subsequent subject.
That earlier order is already set aside by this Honorable Court. Matter has been remanded. After remand, the impugned order has been passed.
In the year 2012, in the year 2012,
type of order Your Lordship has affirmed in other cases. I will.
But whenever, my Lord, a permission is obtained by the petitioners and from a competent authority, and a certificate in respect of the caste is issued, unless and my Lord, it is set aside, how they will say now that my vendor doesn't belong to scheduled tribe. No discussion, nothing else, only on assumption, on presumption.
No discussion.
I will take your lordship to page 78.
Page 78.
Yes.
Third para.
Whenever my lord, this caste certificate is issued in my favor, in favor of my vendor, and due permission was accorded by the given by the sub-collector as per law, and there is an existing order that is not set aside, and ADM will sit over that order passed by the sub-collector by saying so. My lord, page 78. You lordship, can take third paragraph.
Yes.
While examining the Western lease case number such and such, main case number such, it is found that the Learned Tahsildar Bhubaneswar has committed flagrant error when he orders in his order dated such that all the applicants are landlords and scheduled caste communities, while Amino Bhubaneswar Tahsil has reported that Govardhan is a scheduled tribe person having sub-tribe Sara community has not yet been included in the Constitution of India as scheduled tribe. Therefore, while Learned Tahsildar Bhubaneswar settled the case land, while Govardhan as a scheduled tribe person, practiced Govardhan as neither scheduled caste nor scheduled tribe. And even no opportunity of hearing is given to the persons of those persons, my lord, of legal heirs of Govardhan Maji. Only we have been heard. We are the purchasers. And one caste certificate is issued in his favor. And when permission is accorded, that is not taken into consideration.
I am just placing it. The original order was passed after hearing the lessee. You filed a writ application by saying we have not been heard, so matter was remanded. You have appeared before the Learned ADM. Learned ADM has framed issues and discussed. Here, there is no caste certificate issued. Earlier, RI has reported that he belonged to Sara caste, which is a scheduled tribe. That is also a fraudulent, the fraud has been detected by the ADM, that you obtained the land by claiming that you are a scheduled caste person, whereas the RI report reveals that you are a scheduled tribe. But the Learned ADM has discussed, has analyzed this fact and said Sara is not coming under the schedule of scheduled tribe. So you are neither a scheduled caste nor a scheduled tribe. So there is a clear application of fraud. And that is first issue. Second issue is that this is all jungle kisam land, and jungle kisam land is not leasable, which the Tahsildar has committed gross error in granting the lease in favor of a particular person in respect of the jungle land, which is forbidden under Act 1 of 1948. That is clearly discussed. This is like a suit. The ADM has passed the judgment. Your lordship can see the entire judgment. Everything has been discussed. And where the fraud has been committed by this particular lessee and the Tahsildar, it is also connivance with, and your lordship knows in this type of cases, crime branch inquiry was held by order of the Honorable Court, and many Tahsildars were put inside the bar, and all these have happened. So that is why the specific finding which has been recorded, a finding of fact, that you are neither a scheduled caste nor a scheduled tribe person. Because the caste certificate which my learned friend is repeatedly saying, where is that caste certificate? Have you annexed to this writ petition? No.
No, you are the purchasers, your lordship. I have said that.
Is one thing, sir. Where is it?
Para 4 that everything is there.
Impugned order reveals that one RI report was submitted.
No. Your lordship, I will again take it to your lordships. There is a miscase filed by the vendor, and the permission is accorded. Everything will be taken care of in that miscase as per the section 22(1)(b) of the OLR Act.
Certificate
which you are proceeding as like
there is a certificate.
My learned friend knows that whenever under section 22(1)(1)(i)(b) one proceeding was initiated, it is tried up as like as a suit. And evidence was drawn, every document was produced, and thereafter permission was accorded by the competent authority, not that filing of application.
OLR Act 23 permission will be treated as a suit. I don't know where it is.
I am not a suit. I am as like as a suit. That is tried up. Not that your lordships, it is only by filing one application the order will be upheld. By filing one application, my lord, the inquiry will be made, and caste certificate will be produced, evidence will be drawn. Thereafter, my lord, after examining all aspects, my lord, the permission is accorded by the sub-collector.
Whatever is,
my lord, whenever that order is existing, my lord, and by virtue of that order, one has purchased it. Now the ADM will say that no, you do not belong to scheduled tribe. Only that you have got that on the basis of the Amin report. Or the legal, that certificate is available.
My lord is trying to misdirect the issue. This is not the case. If your lordship will go through the impugned order,
you have not filed counter even till today. You have not filed
It
counter.
is
Now,
certiorari
say
proceeding.
that I have.
It is a certiorari proceeding.
I have pleaded in my writ application.
The
record then.
Yes, record is very much there with me. The original case record is with me. The ADM has sent the record to me. Original.
What are the documents placed in record there? We don't know.
This RI report is there where he is stated to be Soro, basing on which the original lease was granted. There was a RI report where it is found that he belongs to a caste Soro and scheduled tribe. Soro is not included in the schedule of list of residential assent.
No, Soro is included. That there is two, the Talbeso and two letters. Only difference of two letters.
And that is
one is one
letter.
doesn't belong to scheduled tribe. But I belong to scheduled tribe. That my vendor belongs to scheduled tribe. Therefore, my lord, permission is accorded by the sub-collector. There is only pronunciation.
But Soro, I will file the entire case records. It is with me.
Why don't you allow him to inspect it?
Yes.
He needs to see it, sir.
This is the original case
Not
record.
like this, not like this. You call him to the chamber, let him inspect it, and then make submissions.
No, he can inspect it right now also.
No, not like this. No. Come to your chamber, he'll inspect. Not like this, sir.
Okay, ma'am.
In the course of his arguments, he can't just inspect. You call him on any mutually agreeable. Next week, we'll call it.
Yes, ma'am.
Item number 6.
The problem is in many of these matters, no counter is filed for years on end.
No counter is filed. That is true, my lords. But the order of the
other
ADM
side doesn't get to know what the case is.
in second round of litigation, that is my respectful submission. In second round of litigations, the impugned order is so explicit and so all the points are taken care of. So it is a matter of like certiorari. Your lordship may say in this type of cases, even if there is no counter, we can argue to justify the order of the ADM.
See,
because ADM has discussed everything.
No. 1 minute. If he has seen your record, original record, then what you say is right. If he has not seen, how is he supposed to know what your case is going to be?
No, he was a party before the ADM.
Not like that, sir. Anyway, we can't.
I will show the entire record.
Let me say there are two documents in the file which the collector does not refer to, which the ADM does not refer to.
My lord,
he can't point it out.
It is better. I will serve a Xerox copy. I will get it Xerox and I will serve to my lord.
You allow an inspection in the. Since you say certiorari, that's the whole purpose is that. It will be better, my lord, if there is suggestion of my lord and friend, if Xerox copy of the record will be.
You get it Xerox and you.
Again, no problem. I will get it Xerox. No. I agree with that, your lordship. I will get it Xerox. It is no problem. I will not put pen to my lord and say. Anyway, we are not passing any order. You decide amongst yourselves.
Yes. Put scanner machine. You can take this off.
Again, I will take it. All right.
Item number 6.
Deeply.
Item number 6 is a single judge matter. If the lordship permits, I can place the matter.
No. If it's single judge, we'll go there. Let's look for the Rasa to listen to
7 also.
7
Same.
also same.
17th April. Both.
Item number 8.
Item number 8, my lord, Mr. BP Tripathi will argue this matter. He is out of station. He has gone to Delhi, my lord. Pass over the matter for the day and take up this matter Thursday, my lord. I pray.
Anyway.
Item number 9.
Well, Lord, item number 9, I'm appearing through VC.
Yes.
Lord, in this matter, 168 workmen. If your lordship will just note, 168 workmen raised an industrial dispute while in service. They sought for two things.
Yes, carry on, please.
They sought for two things. One is the temporary status, and second is the regularization.
1 minute. You're assisting Mr. Mishra.
Yes,
who's for the other side?
My lord,
All right. You've given him copies.
I think the extra copy is another senior. So I'll.
Mr. Just will keep this on board. You just ask your colleague to make copies and give it to the other side. All right. Whatever you're relying on.
Lord, can your lordships have it on the 6th of March? Your lordship have kept one matter on the 6th of March.
All right.
Very great.
Yes, item number 10.
My lord, annexure 5 is under challenge. On the last occasion, your lordship wanted to know how many workmen are there out of 12. I have verified only, my lord, 7 workmen were sardars. They are working, and one is going to retire in this month. And others aged about 53, 49, 48, like that. 12 sardars were there. And my lord, your lordship, if your lordship will kindly go through the order, kindly turn to page 51, one paragraph without, my lord, considering anything. The order has been passed.
Yes.
Only one paragraph without discussing the evidence on record, without taking into consideration the fact of the cases of parties. Nothing is there, only one paragraph order.
That's true. That's true.
Lord, the Lord Labour Court has discussed, they are claiming the sardars. In the agreement, lordship kindly see page 51, finding the admitted position in this case that is none of the settlement nature of work or status or sardar has been specified. The workmen are there, but they are claiming the sardar without doing any work, they will get money, and even if they are not working and now they are claiming the money as the sardar over the workmen. That's the Labour Court's finding. In the agreement, there is no specific sardar word is there. Status of the sardar has been specified. Settlement, the nature of work.
Sardar is supervisor, is it?
Yes.
No, not the supervisor.
Like that.
If it is supervisor, the matter could have been different. They are the sardar. They are bringing some laborers, and they are claiming that they are engaging the laborers, and they are claiming they more than that. They are getting money from them.
My lord, one
Sardar are not
Labor supplier,
supervisors.
labor contractor or labor supplier.
One type of.
My lord, my lord, your lordship, if lordship will kindly turn to page 30, 38, 39. Rejoinder, my lord, rejoinder was filed, claim statement was filed, but where is the discussion about it? Abruptly, the order has been passed without taking note of the cases of
the next line also the Labour Court has discussed. The evidence adduced on behalf of the workmen disclosed that sardar is one amongst the mazdoor, but they do not contribute their labor with the mazdoors, whereas the same time share the wages of the mazdoors for the piece of rated work done by them.
Where from it gone? My lord, where from the it came to
but the evidence is not discussed at all.
Yes.
It's like a series of conclusions.
That's
yeah. See, a perusal of the impugn award reveals that although the parties had led evidence on issues, the Labour Court, the Industrial Tribunal, Bhubaneswar, has, under the heading Single Court's Findings, in a single paragraph containing a few sentences of conclusions, sought to answer the reference against the petitioner workman. Paragraph. Counsel for the management is unable to dispute that there is no discussion of the evidence by the Labour Court of the evidence led by the parties. Full stop. In fact, there is no reason given for conclusions. Paragraph. For the above reasons, the impugn award dated 31/12/2013 of the Labour Court is hereby set aside. And industrial dispute case number 37 of 2012 is restored to the file of the Industrial Tribunal, Bhubaneswar, where it will be listed on 27th March. On that date, the petitioners and the counsel and the management will appear through their respective counsel. The tribunal is requested to proceed in the matter thereafter
May I
and pass a fresh reasoned order, fresh order based on the evidence already led and the notes of arguments already filed, but after hearing both the parties. This exercise will be completed within a period of 6 months thereafter.
May I pre-mail one thing? Your Lordship fixed the date on 27th March to appear.
Yes.
Lordship may direct the industrial tribunal to issue notice to the management because they are not contacting me.
All right. The tribunal will proceed after ensuring that notice is served against upon the management. All right.
Oblace. My lord, urgent copy of your lordship, sir.
Urgent copy. Copy ought to be sent to the tribunal court.
Item number 11.
My lord, what I found out, some other person, namely Abhay Sahu, who is raising the construction there. So therefore, my lord, there is
what happens.
There is a status quo order, my lord, from this court.
So court will pass some orders. What will happen on the ground is something else.
That is true, my lord. What I, my lord, pray learned senior may take instruction on that ground only. If that is, I am ready to give, my lord.
Mr. Mohanty.
My lord.
What instruction?
They are raising the
You are
construction.
saying that there is some construction going. That must have been leased out to somebody else.
Construction by
not leased out, allowed to be occupied.
My lord, the state is a party and BDA is also here a party.
I keep saying the order, court will sit, give a very detailed judgment. You people will argue something. Something else is happening on the ground.
My lord, I found out that.
And suddenly, some 3 years later, Mr. X will come up and say, I have never been heard.
It's only paper decree. You have the satisfaction of the biggest judgment.
That's why the homework needs to be done before you argue.
I have tried contacting him several times. My lord, only on the Friday I have contacted.
You better file an affidavit, additional affidavit. Mr. Monty, now this is a clear indication that something else is happening.
My lord.
You ask whoever is the officer, these people will have to go to the site. All these kind of matters. The officers don't go to the site. We don't even know what's happening there.
But there is a counter affidavit here.
No, that affidavit must have been filed some years
2015.
ago. So everything is so much has changed, sir. See, unlike the old civil suits, if you filed a civil suit, somebody will put a board saying there is a subject matter of an order of a court and all that.
Sub judice in law.
Writ petitions, nothing like that happens. So.
But it is near
you can be sure some real estate agent has actually sold it to somebody else without anybody knowing anything.
One of the most important place of the capital city near Nico Park.
So, my lord, my predicament is the land will be, my lord, that will be landlocked, my lord. I have no passage to go through the public road. That is the only submission.
That is the only predicament. Sir, some years later, that will also emerge. Everything will happen.
Lord, I'll file an affidavit to that, Lord.
Instruction regarding current status from the GAT party.
So you better file an affidavit, sir.
My lord, I'll do that.
Stay on board.
Item not 12.
Bharatiya Janata Party. Today you have full complement of all your friends.
Minor. The real party has to come, minor. For whom we are getting in trouble. For whom our lease could not be done, minor.
Mr. Bose will take serious objection if you say he's not the real party.
No, minor, he is never the real party. He is an intruder. No. He has forcefully occupied that land once the government.
No, it's not a fact.
He is an intruder to the property.
My lord, kindly see. Well, one by one, let us.
Rather, I am the real beneficiary of the lease. I should get the lease.
Nobody is nowhere. Now,
That my
as
senior,
per transaction, somebody else there.
let my senior.
Now,
Two
as per
parties are
paper
fighting
transaction,
for government land. He is saying that it is my land. He is saying that no.
I'm not telling you, I have asked for this.
My lord, by virtue of a order passed by this honorable court, your lordship remanded the matter to rehear my lease independently. The court, the RDC says, because I have rejected earlier, I will not rehear.
But kindly say, one by one, it will be better, my lord. My lord, one by one, it will be better.
Yes.
For all purposes.
Well, let my senior complete. I will address you.
18359. 18359.
183.
Who according to you is your real opponent?
My lord?
Who according to you is your real opponent?
I couldn't understand.
Who according to you?
Real is the newly added in the list.
Who's that?
They are the party. They should be heard first, my lord.
Who is that, sir? Which is this newly added?
The 4 cases, my lord,
My
in
lord,
the list.
that WPC number 13,582 of 2017, filed by one P.L. Chakrabarti, who is the granddaughter.
Yes, I am voting for him only. Right. So, I am voting for him, my lord. Let him start his case so that it will be better.
He is appearing for Bharatiya Janata
No. After 5 years, he has come challenging the order, my lord. In his own order, everything is clear cut. The order on the challenge is clear cut. My lord,
Do you have a case of your own?
yes, I have.
Let us see.
He's hoping you will all contradict yourself and he will be safe.
My lord, let me submit, my lord.
Mr. Hotta should start because he is the main.
No. One senior advocate is there.
Senior may be there because you are.
He is claiming that he is the only.
So your case is 18359.
Yes. All right.
Yes,
all right.
you.
I am now coming to the order, my lord, which my senior, learned senior has challenged it in a case, P.L. Chakrabarti. 4 cases have come. They have submitted one copy of the writ petition because I am made a party. My lord, the history of the...
How big is this land and what are you...
I am coming. It is dealt by the RDC. But how the case is, my lord, there was a land in 1987. It was leased out. My lord, it was leased out.
1 minute. This is in
J. M. Sen.
1 minute, sir.
My lord.
I'm new to Orissa. This is in Sambalpur town.
Yes, ma'am.
Yes, my lord.
Okay.
It is in the name of Jogendranath Sen, my lord. Now,
what is the extent of the land?
It is 1.43 decibels of land. So 1 acre plus 430 of decibels. My lord, this is in the year 1890s. So the building was constructed by the Jogendranath Sen, the lessee.
How did he get it?
My lord, kindly see, there is the orders.
No list of dates prepared. You're not prepared list of dates.
No, I have not prepared. No, not necessarily. Let's go through the things. It will be better, my lord.
Any of you has prepared list of dates?
Yes, I am coming, my lord.
I would have date rules.
In a matter like this, there must be list of dates.
There has to be a date, yeah.
And there must be a consolidated because your list of date will definitely be different from his list of dates.
Well, let me submit. Somebody let them give, my lord. It is in the year 1897, my lord. It is 1987. He constructed the land, my lord. In the nutshell, I am submitting, my lord. Thereafter, he died. It was for 90 years lease, my lord.
Who Jogen died?
My lord?
Who died? Lessee died.
Lessee died. Now, this has been mitigated again in favor of his son, Jyotiranath Sen. Also, he is J.N. Sen. This Jyotiranath Sen, my lord.
What is he?
My lord?
What is he?
Jogendranath Sen's son, Jyotiranath Sen.
So Jason.
J and Sen. J and Sen. Both are J and Sen.
J and Sen, son of J and Sen.
J and Sen. My lord, during his time, this 1.430 decimals of land was reduced to 1.380 of land.
All right.
And the plot was Nazul plot.
Actually, we've lost track of dates now.
My lord.
We only know somebody was there, somebody died, his son was there.
It is not actually important now. These dates may not be important, my lord. The facts, my lord, will understand.
How?
This is, my lord, the fraud has been committed. Fraud has been committed.
Dates will simply understand facts.
I'll supply. I'll supply.
You're not supposed to supply dates. There has to be dates.
Submit. All right. Sorry, man.
No.
Two plots, my lord. The original plot 143-848-1837 was reduced to two plots, 1170 and 1175. 1170 consists of area 1.340.
So the original lease was how many years, sir?
90 years.
98 years?
90 years.
90 years.
Well,
so there itself is a contradiction. Have you seen this list of dates?
No, I'm not sure.
But what I find from the Tahsildar's affidavit, no lease deed has been registered in favor.
No. That is a separate. This is a subsequent. But
that is your list of dates, not his list of dates.
You are saying that is subsequent one.
That they did not pay the premium.
Sir, as it is.
That is 1987.
Sir,
that is regarding 87.
As it is, Mr. Mishra's list of dates is different from yours. I'm just giving you the bad news.
No, it's not a bad news, my lord.
No.
My lord is the champion of justice. You will find out what is inside.
No, for us, I don't know. For
the
you,
truth will come out, my lord. They are standing on false facts and fraud. I am standing on truths. I am still existing on the land since 1967. From Johnson to BJP. My lord, Lal Krishna Advani visited. Sushma Swaraj has visited. Even Bajpayee on the way stepped on that land. It's not a small thing, man. And recent LOP, leader of opposition party, sits there because it is in his constituency.
Now they're all worried. Wherever these people have visited, what you people will say? You will say Lal Krishna Advani visited this house in Sambalpur.
No, that is meeting. They held meetings. Way back in 1980s. Right?
My lord, what I find, this is a fit case where all the parties should be relegated back to the civil court to work out their remedies. Because there are several factual disputes.
RDC has played the mischief. I will come. No. Let us see one by one. RDC to reconsider each and every party here, everybody. RDC has elaborately dealt with the matter.
No, sir. Just to tell you why we said your list of dates is different from his. You said it's a 90-year-old lease. What is the date of the lease according to you?
It is in
Khasana lease, Nazrul lease, or
87. 2011, 1897. 1897.
So 90-year lease will go till 1980 something.
No, 67. Thereafter the independence came. Government so much extended to 1960, 1960.
That's what I'm saying. See, his list of dates says the lease deed came to an end on 31/3/47, even before independence.
No, that chart will be better.
So you better give your date chart.
My lord. So let it come next week, my lord. Next week, let it come, my lord. I will take 2 days time.
Mr. Manthi, I think you should prepare a list of dates. That's the best. All their listed dates will contradict each other. You can be 100% sure. They're not going to agree on list of
dates. My lord, his case is also on. He will come with a contradictory statement. Because my lord, kindly see the one point, my lord. RDC has pointed out how the RI created fraud because he has given the certificate that the PLE is in occupation. Whereas when I am still on the line. Good. All right.
All right.
Item number 13.
So next time it's called out list of dates or no list of dates. What you want?
Yes, yes.
There.
No, that much. I'm not passing any orders.
And next week, madam. It's not in this list. No.
Item number 13.
Please, Your Lordship. And for the opinion number 2, Your Lordship, as a glance to order dated 5th of October 2025.
Lord, it's a case filed by the management.
I have filed an application for 17B in terms of the order passed by the Honorable Appeals Court. One part is the revised wages, second is that unpaid wages of the 17B.
Lord, management here at the receiving end. Prajatantra Prachar Samiti, my Lord, in a very bad shape of its financial condition, almost closed. 100 publications per day, 150 publications per day.
Then 17B will come in your way, sir.
Lord, 17B always will hurt me, my Lord.
Yes.
Lord, all that I can pray is he has given me a calculation saying that he is entitled to get 8,50,067.
Yes.
But let me.
Only other option is you go for mediation, you settle it.
They will not, sir. They will not. In all other cases, Your Lordship, are directed for mediation.
No, he's saying he will go.
Will not.
I'll go.
No, sir. Because they want.
What is this? He's saying
in all cases, earlier Your Lordship also directed for conciliation. They have asked for 50,000 on previous cases. So it is not possible.
But in any way of the matter, let me just have my submission before Your Lordship on twofold, my Lord. 17B, whatever he claims here, my Lord.
No, but in labor matters, sir, 17B, without 17B, you can't go forward.
I can't go forward, my Lord. I can understand that. Let me, but then the way the calculation he has
No, you
given-
make if you want to go through the calculation, you go through it. You put it to your party.
Let me.
And let them not offer some 50,000 and all.
No, not at all. I talked to them yesterday also.
Then you put that figure to him and come back. This calculation you given him?
Yes, my Lord. I received a copy.
All right. Just keep this on record. All right. We'll call it.
Item 14.
May I please, Your Lordship?
Yes.
Your Lordship will kindly recollect with reference to page 6 of the writ application, paragraph J. Your Lordship was pleased to call for this record. Today morning, I verify with Your Lordship's registry, but the record has not come. If the record comes, I will also have to
We'll follow it up, sir. We'll follow it up. We'll call it.
And I am also praying that today I also send with pen drive for a copy.
Yes. Please. Find out why the record is not.
Will it come next week?
Yes. Right or left? All right, sir. We'll do it. We can't say that. We'll see.
Next
Item 15.
It will be on board, Your Lordship.
It will be on board, sir.
My obligation.
Lord, in item 15, Lord, this matter relates to claim of a transformer loss, my Lord. If the supply has been made through LT metering system, that is after the transformer installed metering is done on LT side, my Lord, then consumer is liable to pay the transformer loss as per regulation, my Lord, 54.3 and so also in 93.9 of OERC supply code, my Lord. My Lord, on last occasion, Your Lordship,
Mr. Mahapatra has some difficulty, may put up next week, my Lord.
He was in VC.
All right.
VC
All
is
right.
not operating.
1 minute. Okay. We'll call it next.
My Lord, this judgment, Your Lordship, pardon me, Supreme Court judgment, my Lord, regarding that 56 limitation, my Lord, whether the claim which was not raised and raised after a long time, my Lord, whether this claim is barred by under section 56(2) of the Illicit Act, my Lord, in the Prem Kotex case, my Lord, I am submitting 2 copies, my Lord. My Lord,
No, wait, let him come. Let him come, sir. Otherwise, it will all get lost. All right. Mr. Das, Mr. Shaktidhar Das. Which is the matter you're mentioning, sir?
18, the copy of the counter affidavit I require. There is a noting
18.
there.
18.
Yes. 18. Copy not served. I have been asking 3 times, nobody giving me a copy.
But this is some private, this is...
No, it is state's counter. State's counter I need.
In this case, I am appearing from the work board, and since it is a nature of certiorari,
So it can be.
Niyamati,
So, Mr. Niyamati, you have filed a reply.
I have filed a reply, but since
I think-
it is a writ of certiorari.
No, have you supplied a copy to Mr. Das?
I will verify. ma'am.
No, please do that.
I have filed it. I have filed it in the court, but
No, please give a copy to him.
Okay.
We'll call it next week, Mr. Das.
Obliged.
All right.
In this case, I am for the appeal party. I have already served the copy.
You've served a copy.
I am appeal party number 1, madam.
I don't know. You just talk to Mr. Das. He says he does not have any contact. All right. Yes. 16. 15 is over.
Item 16.
Ma'am, may I please your lordship, my lord, I have been authorized by Miss Naik to conduct this case because Miss Bahel is no more.
Oh, I see.
My lord.
All right. Next week, we'll call it next week.
My.
Item 17.
In item 17, I am for the opposite party, my lord. In the connected writ, my lord, I am the petitioner. That writ petition has been disposed of as non-prosecution, my lord. So for restoration, I have filed a CM appeal, my lord.
Where is that?
The CM appeal is tagged, my lord. Is tagged.
All right. So the CM appeal for the reason stated therein that application is allowed. And what is the corresponding 14324 of 2014 is restored to file. All right. You're there, sir.
I am for the 395, first matter.
You're the petitioner.
I am the petitioner. Can it be taken up today or maybe some other, right? Because his case is first 2014. I am 2015.
I am ready to place my matter.
Okay. Carry on then.
My lord. My lord, the petitioner has challenged the award passed by learned industrial tribunal, my lord. That is at annexure 1 of my writ petition, 14,324 of 2014, my lord. Lordship, may kindly see the relevant page, that is page 12, running page 12. 5 issues have been framed by the learned tribunal, my lord. Lordship, if sees...
But you got compensation of just 25,000. How many years did you work?
Lordship.
How many years did you work?
I have worked for more than 6 years, my lord.
What is 25,000, sir?
No, he was working as a contractual labor, maybe because no records are available. After 13 years, he didn't pursue it, and after 13 years he has come.
Whatever, sir. What is your unit? What do you do? What is your unit?
That is a
municipality, my lord. Kendrapada municipality.
So it's not as if you're out of money or something.
My lord, the
25,000 is nothing, sir. Enhance it to 1 lakh.
It's too much for them. Why? Because it's a municipality corporation where from there. It's all public money only. And that is true. There is no industry. He has never raised a dispute before the management. He has straight gone to the labor court.
My lord.
Not to the labor court, to the labor authority, DLO and this thing. And the findings of the labor, my award is also totally perverse, contrary to the provisions of law and nothing.
The issues were dealt with at page 16, running page 16.
The main issue that it is not an industrial dispute, that has not been, though it has been there in the issue number 3 and 4, it has never been dealt. And there are case laws there, and after 13 years, where from the management will get the records? And there are
13 years plea is not right, my lord. I have applied for I have filed a complaint before the DLO immediately in the year 1999, my lord, through the after my termination, my lord, in 1998, I have filed a complaint before DLO, my lord. He through the labor union, my lord. He has issued notice to the Kendrapada municipality, but they didn't appear, my lord. He has also sent a memo so that to the union so that they can remain present in the joint inquiry, my lord. On the joint inquiry date, they didn't appear. They took time, and in the 1999 cyclone, my lord, my case records were displaced. Even after my repeated approach, they didn't consider anything. Thereafter, in 2011, my lord,
what happened for those 12 years? That's the question he's asking. Cyclone happened in 99.
Yes, my lord.
The next date you're telling
I repeatedly approached the DLO authorities of DLO, but they didn't. They kept me waiting that your case record will be available. We will trace out, my lord. But thereafter, my lord, my case was reopened and the case was posted for conciliation, my lord. In conciliation also, they didn't appear, my lord. Due to the conciliation failed, my lord. Thereafter, the issue was sent to the industrial tribunal, my lord.
Translation ended in a failure, then the reference. But
Yes,
from 99 to
The
2012,
problem is how will documents be available? If
My
you
lord,
go,
in the-
if you
in
go
series
to
of
the court
judgment-
after 13 years and 14 years, who's got documents?
My lord, in paragraph, my lord, that I'm stating, my lord.
See, para 3, the written statement itself, they say they don't have the records. No document
My
is
lord,
available.
in para 3 of page 2, in
See, every
written
year's delay
statement of-
means it becomes more difficult for you to establish your claim.
my lord, the tribunal has held, my lord, that they could not produce the document, but they are saying that this person, Premananda,
might have been working, might have been working, not that he was working. And he has produced a certificate
They are to produce
signed
the
by an
certificates,
executive
my lord.
officer, Mr. Dr.
Those documents
P.K.
cannot
Das.
be with me, my lord.
He was not the executive officer that time. It's a totally forged certificate they have produced before the labor department tribunal.
My lord, subsequently, first I have approached this honorable
and
court.
we have-
After
we have
they,
filed two
after
supporting
getting
documents
notice,
that
they
was
have
not
filed this writ application, their writ application, my lord.
Actually, in a case like this, mere failure to produce records, you can't draw a presumption against them. If you yourself have gone after 13 years.
My lord, I have approached the labor officer, my lord. My case was.
It's not about labor officers, sir. When do you seek reference and when does it come to the tribunal? That's the question. No wonder they have no records. And your petition challenges the award.
I have also, my lord, judgments that saying that if the termination is held to be illegal, then I am liable to be reinstated with back wages, my lord. Honorable Apex Court judgments, my lord. I'm supplying, my lord. No, my lords. Even there is no stay, they have not paid the amount.
Because we have challenged it. Because we have challenged that. No. Suppose we pay him. Suppose in the matter where we are challenged, we succeed.
This is also the case where the petitioner was a daily laborer and he was reinstated with back wages, my lord. Recent judgment, my lord.
Because there are citations of the Supreme
My lord,
Court
just
also
because
that
the
in some delay.
complaint petition was pending before the DLO, my lord. That's why thereafter the petitioner was approaching his remedy, my lord. In the last portion, my lord, if your lordship will see at the end, paragraph 15, my lord. The impugned judgment is hereby set aside. The appellant workman shall be reinstated in service of the respondent within 6 weeks from today. He shall be entitled to the back wages, my lord. Here also the petitioner was a daily laborer.
My lord, I have a citation of Bombay High Court, where he has minimum 24 cases of the Supreme Court has been discussed. And finally, they have given the conclusion there. And this matter is exactly the same as for this matter. The judgment of 2011.
This case, bottom of page 4 and top of page 5.
The record indicates that both the labor court and the single judge elaborately considered the depositions of parties as well as the evidence of record. In fact, the appellant workman had applied under the RTI, eliciting the relevant documents to substantiate his claim that employees junior to him were reinstated in service. The management was unable to refute the material on record. On the other hand, it claimed the inability to produce.
They have to record, and the tribunal simply presume because they don't have any record.
My lord, they
were engaged with them. The whole problem. Somebody must have a record. There must be some basis for the tribunal to come to conclusion that you were employed by them.
Probably my lord's mic is on.
No, the difference is, in this case, the workman applied for and got the record.
Yes,
in your case, you don't have any record. They don't have record because you've gone to the tribunal after 14 years, which is not the case here. Here, it is not as if the workman waited for 14 years to go to the tribunal.
My lord,
and so the Supreme Court had some basis on which to go by. Some record was there. In this case, in your case, except your deposition, there is no record. And they don't have a record because you have gone after 14 years. This judgment will not help.
Lordship may call this matter any day next week, my lord. May I collect the instruction from the client, my lord? So
Bombay High Court, your lordship can go through it. Exactly the same case of this.
You better give him copies, sir.
Any relevant part, President. Para 19, my lord, is very important. Where regarding delay and stale claim, everything has been recorded.
We'll examine it next week. All right. We'll stop here.
I